Mouthful. Okay, with that said, I want to now turn it over, as Stacy introduced a little bit earlier, from our Palm Beach Gardens office. This is one of our board certified specialists in condominium and plan development law. There aren't many of those in the state at all, and we have two of them today. Danielle, please take it away. Nice to see you.
Hello, good afternoon or good morning, depending on where you are. Thank you very much, Nest Core Partners and Stacy, for hosting us today. And thank you, Jeff, for your assistance as always. As they said, my name is Danielle Brennan. I am a board certified specialist in condominium and plan development law here with Kay Bender Rembaum in our Palm Beach Gardens office. We do have a bunch of other office locations. We have one in the Tampa area, one in the Orlando area, our main large office in Pompano Beach, and we also do have some Miami-Dade office space available by appointment. I am one of 10 board certified specialists here with the firm. Most of us in condominium and plan development law, we do have one attorney who is board certified in construction law. And we have a total of 26 attorneys and lots of support staff. So we have a whole team that helps us do our representation, provide our expert legal services to condominium associations throughout the state of Florida. This is what we do day in, day out. We don't do anything else. So we really are specialists and experts in providing legal representation to condominium associations. Let me go ahead and share this so that you guys can see presentation. All right, so as Jeff had mentioned, we're going to hold off for questions until after this portion of the segment is over. If you have lingering questions, our email addresses are provided for you. You can send us an email. Again, we can't provide you with any specific legal opinions. We don't represent your association, so we don't have your governing documents, and we don't have that attorney-client relationship. However, if you're interested, you can certainly reach out to us and we can, get you a retainer package. If you have an attorney already, you're happy with them, certainly stick with them. But if you're looking for an attorney or you don't have an attorney, please keep Kay Bender Rembaum in mind. We do have a website that has some awesome resources, either Legal Morsels or Rembaum's Association Roundup, if you're looking for some information that you can read about these ongoing topics for condominium associations and community associations in Florida. Let me go ahead and show you what I consider my catfish photo, because that's an old photo. That's me well over 13 years ago of my time here being with the firm. And you guys will meet Andy in a little bit. And we will jump right into the information. As Jeff mentioned, this is all for informational and educational purposes only. This is not providing legal advice. Go ahead and contact your association's attorney if you need some legal advice or need a legal opinion about something. And I also like to start this particular topic with an apology. Reason being is because this particular topic is not going to be applicable to all condominium associations in Florida. It's only going to be applicable to those that are 3 habitable stories or more. So if your condominium does not have 3 or more habitable stories, apologies, because this next area is going to be a bit boring, but we are required by statute to include it in the presentation. And it also has been a matter of hot topic for these past several years since the Champlain Towers collapse. All right, so this initial topic is about milestone inspections and structural integrity reserve studies and the reserves that are required to be maintained in accordance with those studies. So first off, let's talk about a milestone inspection. What is the milestone inspection? It's a structural inspection of the building that would include all the primary structures and primary structural systems of the building. What does that mean exactly? Well, your foundation, your masonry bearing walls, floor and roof systems, concrete framing systems, windows, doors, building facade, all of those members are going to be inspected during your milestone inspection. It's performed by an architect or an engineer or a team of professionals that has an engineer or an architect leading the group. And the purpose of the milestone inspection is to attest to the life safety and adequacy of the building structural components, and to the extent possible, determine the general structural condition as it affects the building safety, and to determine whether or not there's any work that needs to be done. What it is not, however, is to determine if there's a condition of the building that's in compliance with Florida Building Code or the Fire Safety Code, right? We're just trying to determine if there are structural issues with the building, not to determine code compliance. When does an association, a condominium, need a milestone inspection? Well, thankfully for those condominium associations that have a condominium that's 3 habitable stories or more in height, local government is going to be the one to say, hey, you guys need a milestone inspection and you need to get one done. So if you are 3 habitable stories or more in height, just know that you're going to be subject to a milestone inspection at some point. Again, this is only applicable for our residential condominiums, not going to be for our commercial buildings or for any single family, 2-family, 3-family, or 4-family dwelling with 3 or fewer habitable stories. If you have a mixed use or a condominium hotel, the milestone inspection report has to be arranged by that residential component and any owner of the portion which is not subject to the condominium form of ownership. They're each going to be responsible for their portion of the milestone inspection, and they're responsible for their own costs. When do you need one? Okay, so you determine, okay, I'm a 3 or more habitable story condominium. I need a milestone inspection, but when do I need it? That initial milestone inspection has to be performed by December 31st of the year in which your building turns 30 years old. When do we have the birth of a building, you ask? Well, it's when the certificate of occupancy has been issued for your building. If there's no date of issuance for that certificate of occupancy, then the date of issuance is evidenced by any record from the local building official. If your building had reached 30 years of age before July 1st of 2022, your initial milestone inspection must have been performed before December 31st of 2024. And if your building reached 30 years of age after July 1st, 2022, but before December 31st, 2024, then your initial milestone inspection must have been performed before December 31st of 2025. And then another milestone inspection will need to be performed every 10 years after the date of that previous milestone inspection. As I had mentioned before, local government, your local enforcement agency, is going to provide you with a notice to say, hey, you're due for your milestone inspection. The local enforcement agency can require that first milestone inspection be performed by December 31st of the year in which the building reaches 25 years of age instead of 30, based upon local circumstances, like how close your condominium is to salt water. Because as we know, salt water is corrosive. So if you're going to have an issue with your building's facade, your building's envelope, which is waterproofing, and salt water is getting inside of your condominium building, it's going to have a corrosive effect on the rebar or whatever metal components you have forming part of your structure. So they do usually tend to have a heightened requirement for buildings that are closer to the salt water. The local enforcement agency can also extend the due date for that initial milestone inspection if there's good cause that it cannot be completed. If the owners of the building have entered into a contract with an architect or an engineer to perform that milestone inspection and it cannot be reasonably completed before the deadline, or there are some other circumstances that would justify an extension. The local enforcement agency can accept an inspection report prepared by an engineer or an architect for structural integrity and condition inspection of a building that was performed before July 1st of 2022. if it substantially complies with the milestone inspection requirements. And you may be thinking, okay, well, what type of inspection is that? Well, in certain counties, once a building reaches a certain age, they're required to have a recertification done. So it could be a 40-year recertification. I think that's the Broward County requirement. And I do believe that Miami-Dade also has one. I'm not sure if it's 40 years or not. Again, here I'm based in Palm Beach County, so it's a little bit different depending upon where you are. Regardless of when your inspection was completed, the association still has to comply with the requirements to provide owner notice, which we will discuss. If a previous inspection report is accepted by that local enforcement agency, then that previous inspection is deemed your milestone inspection, and the deadline for that subsequent 10-year inspection is based on the date of the accepted previous inspection. So it would be a date prior to July 1st of 2022. You would calculate that out 10 years, and that's when you need your next milestone inspection. So we've determined, yes, we're 3 stories or higher for our habitable stories for our condominium. We are 30 or 25 years old, depending upon where we are. So we need a milestone inspection. Now, what do we do? Again, the local enforcement agency is going to provide written notice of the need for the inspection to the association and to any owner of the portion of the building which is not subject to the condominium form of ownership, like if you have a mixed use or a condominium hotel. It's going to be provided by certified mail, return receipt requested. After the association receives that notice, then it must notify the owners of the required milestone inspection within 14 days after receipt. The milestone inspection has 2 different phases. We have phase 1, which is a purely visual inspection, and phase 2, which is both visual and may include destructive or non-destructive testing. For our phase 1 milestone inspection, the architect or the engineer has to perform a visual examination of both the habitable and non-habitable areas of the building, which include the major structural components, and provide a qualitative assessment of the structural conditions of the building. That architect or the engineer must prepare and submit an inspection report. There are usually, like I know for Palm Beach County, on the county's website, there's like a link, and the engineer architect can create an account and upload everything online when they need to submit that inspection report. The phase 1 inspection has to be completed within 180 days after they receive notice from the local government. And completion of the phase 1 means that the engineer architect submitted the inspection report by email, US mail, or commercial delivery service to that local enforcement agency. If the architect or the engineer finds no signs of substantial structural deterioration, then they don't need to do a phase 2. However, if substantial structural deterioration is found in that phase 1 inspection, you're going to have to do a phase 2. So what is substantial structural deterioration? Well, it's structural distress, substantial structural distress, or substantial structural weakness that negatively affects the building's general structural condition and integrity. This thought just occurred to me the number of times that I'm going to say structural in this particular phase 1. I hope that there's no drinking game out there. If there were, for, take a shot every time she says structural, you guys are going to have a wild Friday morning, or a wild Friday afternoon. Anyway, sidebar. Unless the engineer or architect performing the inspection determines that surface imperfections are not a sign of substantial structural deterioration, then substantial structural deterioration does not include surface imperfections like cracks, distortion, sagging, misalignment, signs of leakage, peeling of finishes. But as I mentioned before, a lot of times, particularly if you're closer to the coast, those things could potentially be substantial structural deterioration if it's allowed water to intrude and begin corroding the metal structure of the building. For our phase two, as I mentioned before, it has to be performed if there's been any substantial structural deterioration identified during the phase one. It could include destructive or non-destructive testing, depending upon what the inspector finds. It could be as extensive or as limited as necessary to assess the areas for structural distress, with the ultimate intent of determining whether or not the building is structurally sound, or if it needs to be repaired. You do a concrete restoration, something like that, to determine what the work needs to be done. And if the phase two is required, then within 180 days after submitting that phase one inspection report, the inspector performing the phase two must submit a phase two progress report to local enforcement agency with a timeline for completing the phase two inspection. The inspector that does that phase two inspection must prepare and submit an inspection report. Both the phase one and phase two inspection reports have to have a separate summary of that inspection report. And it has to include, at a minimum, the material findings and recommendations in the inspection report to the Condominium Association, if there's some other portion of the building, owner of the building official of the local government which has jurisdiction. The inspection report requirements. So your inspection report has to include the following criteria at a minimum. Have the seal and signature or electronic signature of the inspector. Indicate the manner and type of inspection, phase one, phase two. Identify any substantial structural deterioration, which may have been found during the inspection, and identify any recommended repairs for that deterioration. State whether there's an unsafe or dangerous condition, as their terms are defined in the Florida Building Code. Recommend any remedial or preventative repair for any of those items that are damaged but are not substantial structural deterioration, and identify and describe any items requiring further inspection. Within 45 days after you have that inspection report, the association has to distribute a copy of the inspector prepared summary to each unit owner, regardless of the findings or recommendations in the report. You can't look at the report and say, oh, this report's bad, we don't want to send this to the owners. No, you have to send it to them by US mail or personal delivery to the owner's mailing address, or it can be provided by email if the owner has consented to receive notice by electronic transmission. You also have to post a copy of the inspector prepared summary in a conspicuous place on the property and publish the full report and inspector prepared summary on the association's website if the association is required to have a website, and we will discuss the website requirements in topic 2. The Board of County Commissioners or municipal governing body has to adopt an ordinance that requires repairs for substantial structural deterioration to be scheduled or commenced within a particular time period if they receive a phase 2. So long as the repairs have to be commenced no later than 365 days after receiving the report. If the owner of the building fails to submit proof that the repairs have been scheduled or commenced within the time frame, then the local government has to review and determine if the building is unsafe for human occupancy. If the officers or directors of the association willfully and knowingly fail to have a milestone inspection performed, then that failure is a breach of their fiduciary duty. So it is very important that the officers and directors in the association get their act together once they receive notice to actually get that milestone inspection completed. A local enforcement agency can have timelines and penalties for compliance with the milestone inspection requirements. Now, the Florida Building Commission was required to and has adopted rules establishing a building safety program for the implementation of the milestone inspections in accordance with the building code. And the building inspection program includes inspection criteria, testing protocols, information that the person who you hire and obtain to do your milestone inspection, be it an architect, engineer, or group that's led by an architect or engineer, should absolutely 100% know. All right, jumping from our milestone inspections to our structural integrity reserve studies and the reserves that are required to maintain pursuant to that. A lot of this is going to sound very familiar because it covers some of the same stuff as the milestone inspection. So our structural integrity reserve study is a study of the reserve funds that are required for future major repairs or replacement of structural components of the building, like the roof, load-bearing walls, primary structural members, primary structural systems, right? These are all terms that we discussed pertaining to the milestone inspection. Fireproofing and fire protection systems, plumbing, electrical systems, waterproofing, exterior painting, windows and exterior doors, if they're maintained by the association, and any other item that has maintenance expense or replacement costs of more than $25,000. This can be adjusted by the division for inflation. And then failure to replace or maintain that item negatively affects any of the structural components that are subject to the structural integrity reserve study. Now, the structural integrity reserve study really has two portions to it. There's the visual inspection to determine, okay, this is the status of the building, and this is what would need to be done in order to get it back to the way it was initially within a certain time frame. And then there's also the funding portion of it, the dollars and cents. So I'm sure we'll dive into that as well. So who needs a structural integrity reserve study? Again, this is only for residential condominium associations. They have to have a structural integrity reserve study completed at least every 10 years after the condominium's creation for each building on their condominium property that is 3 habitable stories or more in height. Buildings less than 3 stories in height, single family, 2 family, 3 or 4 family dwellings that have 3 or fewer habitable stories. Any component of a building that's not been submitted to the condominium form of ownership, again, think mixed use condominium or condominium hotel. Any portion or component of a building that's maintained by a party other than the association, like unit owners and commercial condominiums, are all exempt from the need to obtain a structural integrity reserve study. As I mentioned before, there's a visual inspection of the condominium property that has to occur for the structural integrity reserve study. At a minimum, the study has to identify each item on the condominium property that's been visually inspected, state the estimated remaining useful life of that asset and the estimated replacement cost or deferred maintenance expense of that item, and provide a reserves fund schedule for that particular item with a recommended annual reserve amount that would achieve that estimated replacement cost at the end of the useful life of that item. Similar to the milestone inspection, the structural integrity reserve study, the visual portion of it, has to be done either by an engineer or an architect or a person who's certified as a reserve specialist or professional reserve analyst by the Community Association Institute or the Association of Professional Reserve Analysts. I would suggest that that visual inspection portion really be done by an architect or an engineer because they're, I think, me personally, more adept at identifying the structural issues. And then having someone who's a reserve specialist do the dollars and cents portion of it. Any design professional or licensed contractor who bids to perform the CEUs, that's your structural integrity reserve study, must disclose in writing to the association their intent to bid on any services related to the maintenance, repair, or replacement that might be recommended by the CEUs. Any design professional or licensed contractor who submits a bid to perform the services by the structural integrity reserve study cannot have an interest either directly or indirectly with whomever is providing the CEUs or be related to any person that has a direct or indirect interest with that firm, unless there's been a disclosure of that relationship to the association in writing. And contracts for services are voidable if the contractor failed to provide written disclosure, and the design professional or contractor could be subject to discipline. Typically, laws are created because there are some bad actors out there, so there must have been some people who were wheeling and dealing on both sides of the structural integrity reserve study to result in this particular statute, which is fairly new. Um, so there are some conflict of interest disclosures that are required. Associations that were existing on or before July 1st of 2022, which are unit owner controlled, meaning the developer is not electing or appointing a majority or more of the board. They must have a structural integrity reserve study completed or have had it completed by December 31st of 2025. An association that's required to complete the milestone inspection on or before December 31st of 2026 could have completed the structural integrity reserve study at the same time with the milestone inspection period, but the structural integrity reserve study must have been completed, could have been completed after December 31st of 2026. Again, these dates are old. If you're going to require to have a SIRS, a structural integrity reserve study, you really should have had one already. If the milestone inspection required or an inspection completed for a similar local requirement, again, that like 40-year recertification, was performed within the past 5 years and meets the same requirements as structural integrity reserve study, then that inspection can be used in place of the visual portion of the structural integrity reserve study, but you still have to do the dollars and cents portion of it. If the association completed a milestone inspection or, again, something like that 40-year recertification, the association can delay performance of a required structural integrity reserve study for no more than 2 consecutive budget years immediately following that inspection in order to allow the association to focus its financial resources on completing the repair and maintenance recommendations of the milestone inspection. Again, this is fairly recent, as you can see from the slide, and it makes complete sense, right? You want to be sure that the association has the money it needs to make the structural repairs. And then once those structural repairs have been done, I would suggest that your association perform a structural integrity reserve study and then so it can base all of its new projections on the repair that was already done. Typically, I mean, obviously, logically, it would serve to lower the overall reserve funding requirement because you've pushed out the useful life of that particular asset. Okay, so we determined that you need your structural integrity reserve study. You went ahead, you got it. Now, what do you need to do with that structural integrity reserve study? Within 45 days after you've got it in hand, the association has to provide a copy of the study to each unit owner or send them a notice saying that the study was done, it's available for inspection and copying upon written request. If it's requested, then the copy has to be provided by U.S. mail. I'm sorry, the copy or that notice has to be provided by U.S. mail or personal delivery to the address provided by the owner to fulfill the association's notice requirements. And you can use email as a means of providing the copy or the notice, but you have to make sure that you've got consent from the owner to receive notice by electronic transmission. The association must also provide the division, meaning the Division of Florida Condominiums, Timeshares, and Mobile Homes, with a statement saying the study was completed and that the association has provided or made available the study to each owner in accordance with the requirement just discussed. The statement has to be provided to the division in the manner established by the division using a form posted on the division's website. If you guys haven't visited the division's website, I encourage you guys to do so because it does have a lot of resources there for condominium associations that may be valuable to your particular board.
I'll place that link into the chat for everybody.
Okay, fantastic. So we have our SIRS, we've 45 days, provided it to the owners or a notice to the owners, provided it to the division. Now we need to set our calendars for 15 years out. Okay, we need to keep it on our books and records for at least those 15 years. Why 15 years as opposed to 10 years? Because you have to do it I don't know why the legislature does these things, but they do. For those associations that have to have a website, again, we'll talk about those requirements. You have to post it on the association's website. And an officer or director must sign an affidavit acknowledging receipt of the structural integrity reserve study. Again, new law underlined there for you. Similar to the milestone inspection, if the officers or directors of association willfully and knowingly fail to complete the structural integrity reserve study, that failure is a breach of their fiduciary duty. So certainly do not sit on it. If the association is required to have a CEUs, reserves do have to be maintained for those items for which the association is responsible pursuant to your declaration of condominium. The reserves amount for these items must be based on the findings and recommendations of that most recent CEUs. And the association can adjust replacement reserve assessments annually to take into account inflation and any changes in estimates or extension of the useful life of a reserve item that's caused by deferred maintenance. Maybe you do a concrete restoration that would benefit the life of your building's exterior or structural components. You want to be able to take that into account when you're doing your reserves for your next upcoming budget. So there is, a lot of associations, when this law initially came out, they're like, well, how do we determine the useful life, the estimated useful life of our building's foundation? So they enacted something, they being the legislature enacted this particular exemption. So with respect to items for which an estimate of useful life is not readily ascertainable, or it has an estimated remaining useful life of greater than 25 years, then the association is not required to reserve replacement costs for that item. However, the association does have to reserve the amount of deferred maintenance expense, if any, which might be recommended by the CEUs for those items. Now, as we know, with traditional reserves, there is the ability to waive and reduce reserves upon vote of the members. And that remains true for our non-structural integrity reserve study items. You are still able to waive and reduce those reserves by a majority vote of the total voting interest of the association. However, you cannot do so for your CEUs reserves items. Those things are sacrosanct. If you are in a multi-condominium, you can determine to provide no reserves or less reserves than required by statute if you provide an alternative funding method that's been approved by the division. Now, this only applies to those multi-condominium associations having at least 25 condominiums, so very large condominium communities. And that alternative funding method, I have yet to see what that looks like. But it does have to be submitted to the division. The division does have to sign off on it before you can actually implement it. For a budget that's adopted on or before December 31st of 2028, if the association has completed a milestone inspection pursuant or within the previous 2 calendar years, the board, with the approval of majority of the total voting interests of the association, can temporarily pause for no more than 2 consecutive annual budgets, reserve funding, or reduce the amount of reserve funding for the purpose of funding the repairs that are recommended by that milestone inspection. If the association pauses those contributions, then it has to have a CEUs performed prior to initiating funding to recommend an updated funding plan. Again, makes total complete sense. When you have work that has to be done to the structure pursuant to your milestone inspection, which is very similar in many ways to your structural integrity reserve study, you're going to want to focus the association's funds on actually getting those repairs done and then have a structural integrity reserve study performed after they're done so that you can have a better projection and potentially lower your overall reserve contribution requirement on an annual basis. There were a lot of issues when the structural integrity reserve requirements came into being, because now it made reserves funding required, and a lot of people became cash strapped because of it. So they did enact some laws that provided a little bit of options for the association to alleviate the out of pocket for owners, by allowing CERS reserves to be funded by regular assessment, special assessment, lines of credit, or loans. A special assessment line of credit or a loan would require the approval of a majority vote of the total voting interest of the association. And a unit owner controlled association that has to have a CERS can secure a line of credit or loan to fund capital expenses that are required by that milestone inspection or structural integrity reserve study. This does not apply to a developer controlled association. Note that it said a unit owner controlled in the previous sentence. The association where the non-developer unit owners have been in control for less than 1 year, or an association controlled by one or more bulk assinees or bulk buyers. Now, it's unclear if this exception also applies to the funding of CERS reserves by regular assessments, special assessments, line of credit, or loans. But the line of credit or loan has to be sufficient to fund the cumulative amount of any previously waived or unfunded portions of the reserve funding amount and the most recent CERS. Funding from the line of credit or loan has to be immediately available for access by the board to fund required repair, maintenance, or replacement expenses without further approval by the members of the association. So once that line of credit or loan is in place, the board needs to be able to draw from it as needed. Reserve funds and any interests that are accruing must remain in those reserve fund accounts and can only be used for those authorized reserve expenditures unless a majority of the total voting interests of the association have approved for their use for other things. However, when it comes to our structural integrity reserve study items, it can only be used for those particular items. We usually use this particular portion of the statute, the vote to allow use of reserve funds for other purposes, as a means to establish pooling. However, and it was essentially because the statute did not provide for pooling of reserves at all. So we used this as a means of doing that. However, the legislature put into the statute pooling specifically for our structural integrity reserve study components. These reserve accounts can be pooled for 2 or more of the required components. However, you can't pool CERS components with non-CERS components. You have to have all CERS in a pool without inclusion of any non-CERS components. The reserve funding indicated in the proposed annual budget has to be sufficient to ensure that all available funds meet or exceed whatever projected expenses are going to be coming from the components in that pool. And a vote of the membership is not going to be required for the board to change from pooling to straight line or straight line to pooling for our structural integrity reserve study items. If the local building official determines that the entire condominium building is uninhabitable due to a natural emergency like a hurricane flood, the board can pause the contribution to its reserves or reduce reserve funding until the local building official determines that the building is habitable. Any reserve account funds that are held by the association can be used as determined by the board to make the condominium building and its structures habitable. Again, we really want to be focusing our monies on making the building safe rather than contributing to reserves. If it's determined by the local building official that the condominium building is habitable, then the association has to start contributing funds to reserves once again. So we know we have our milestone inspection requirements. We know we have our structural integrity reserve study requirements. What other requirements are out there that are similarly related? There are structural integrity reserve study requirements for developers. They're a little bit different than what's required for unit owner controlled associations. Um, we don't have a height requirement or age requirement here. The developer still has to include with their turnover inspection report a structural integrity reserve study, which attests to the required maintenance condition, useful life, and replacement costs of the roof, the structure, fireproofing and fire protection systems, plumbing, electrical systems, waterproofing and exterior painting, and windows and exterior doors. And note that the requirement for windows and exterior doors here is not conditioned upon whether or not they're maintained by the association. So regardless of who maintains them, the developer's turnover report does have to include a structural integrity reserve study for the windows and the exterior doors. Now, each contract for the sale of a residential unit must contain a conspicuous type, certain disclosures regarding the milestone inspection or structural integrity reserve study. A contract that does not have these disclosure requirements is voidable at the option of the purchaser prior to closing. If an association is not required to have a milestone inspection or structural integrity reserve study, then each contract for the sale of a residential unit must contain inconspicuous type, a statement indicating that the association is not required to have the milestone inspection or structural integrity reserve study as may be appropriate. If the association is required to perform a milestone inspection or a structural integrity reserve study and has not completed those inspections or studies, then each contract for the sale of a residential unit has to contain a conspicuous type of statement indicating that the association is required to have them, but has not completed that study or inspection. Or if they are required and they have completed it, then the contract has to provide that an inconspicuous type. There are certain disclosures that are provided by statute. Each prospective purchaser who has entered into a contract for the sale or for the purchase of a condominium unit is entitled at the seller's expense a current copy of the inspector prepared summary of the milestone inspection report and the most recent structural integrity reserve study. After the reports are provided, then the buyer has 3 business days to cancel the contract upon written notice to the seller. And this right to void the contract cannot be waived. So it's very important for sellers to realize, oh, there's this termination provision that they're provided by statute that cannot be waived. So you want to be providing that as soon as possible, or at least your owners do. So there is a definition for the term dispute that's provided by statute. As you will likely hear from Andy in the presentation, there is for enforcement of the association's governing documents or Chapter 718, which is our Condominium Act, a number of disputes have to go before an arbitrator or to pre-suit mediation before you can take them into court and litigate. Well, the term dispute has been expanded to include the failure to obtain that milestone inspection report or the structural integrity reserve study, the failure to fund reserves as might be required by the structural integrity reserve study, or the failure to make or provide necessary maintenance or repairs of the condominium property that's recommended by the milestone inspection report or your structural integrity reserve study. Excuse me. However, these disputes aren't going to be subject to arbitration. Rather, they have to go to pre-suit mediation prior to litigation if it's unresolved at mediation. So yes, the term dispute has been broadened, but they really want you to sit at the settlement table rather than going into mediation or arbitration for it. All right, so now all of my condominium association board members and managers who have condominiums with less than 3 habitable stories, you can wake up now, because we're going to start talking about elections, official records, and record keeping. So for our elections, when do we need an election? Well, a vacancy on the board that's caused by the expiration of a director's term has to be filled by an election. If a vacancy occurs on the board before the expiration of a term, unless it's by recall, then that vacancy can be filled by a majority of the remaining directors or even the sole remaining director, or the board can choose to hold an election to fill that vacancy. Our election timeline, is fairly simple. 60, 40, 35, 14, right? So we always follow that same structure for our condominium elections. Not less than 60 days before your election, you have to provide a first notice of the date of the election. Then unit owners or other eligible persons who want to be a candidate for the board have to provide their written notice to the association at least or not less than 40 days before the scheduled election. Then the candidate has the option to provide a candidate information sheet not less than 35 days before the election. Now, the information sheet cannot be larger than a single side sheet of paper, 8.5 by 11 sheet of paper. And the association is going to be responsible to make copies and then include it in the mailing of the second notice. And that second notice has to go out not less than 14 days, nor more than 34 days, because remember, we have at least 35 days to provide. We have 35 days before the election to provide that candidate information sheet. So naturally, 34, 14, we're sending our second notice of the election to our owners. It's going to include the agenda. It'll include, if you're having an election, i.e. not having an election by acclamation, which we'll discuss, you're going to have your envelopes, your ballot, in the mailing of that second notice. And the ballot does have to list all of those candidates alphabetically by surname. The number of directors. So you're going to want to look at your governing documents really to determine the size of your board, because here the statute just provides a gap filler. So unless your governing documents provide otherwise, your board's going to consist of 5 members. Unless you have 5 or fewer units, then your board would consist of at least 3 members. Typically, provisions concerning the size of the board will be in the articles and bylaws. So look at both. If the articles of incorporation or the bylaws allow directors to serve terms longer than 1 year, then the terms of all directors expire at the annual meeting. However, if you have a timeshare or non-residential condominium, you're not going to be subject to these limitations. You could provide for a staggered term, like a 2-year staggered term, which a lot of associations do. And if all directors' terms would otherwise expire, but there are no candidates, so you would have a rollover situation there. A director cannot serve more than 8 consecutive years unless approved by 2/3 of all votes cast in the election, or unless there are not enough eligible candidates to fill vacancies on the board. So only board service that occurs on or after July 1st of 2018 is used when calculating a director's term limit. So if we do the math, we know that, okay, so for those board members who have been serving on their board continuously for 8 consecutive years since this particular limitation came online, are gonna be subject to this term limitation. And I'm sure there will be a slew of different division cases coming up soon concerning this particular term limitation. Now, in a residential condominium association that has 10 units, more than 10 units, the co-owners of a unit cannot serve as directors at the same time unless they own more than 1 unit. Excuse me, or unless there are not enough eligible candidates to fill the vacancies on the board at that time. Notice that it says they can't serve as directors. That doesn't mean that they can't run. So if you both own one unit in your condominium, you both can run for the board, and perhaps one of you gets elected, the other one doesn't. Well, then there really is no issue there. It's just a matter of if you're both elected, whether or not you can both serve as directors at the same time. Now, you heard me mention before the term election by acclamation. An election by acclamation occurs where there are not enough candidates to warrant balloting. So if the number of vacancies would equal or exceed the number of candidates, then an election is not required. What we have is an election by acclamation, and those candidates will take their seat on the board at the annual meeting, whenever that occurs. There is no quorum requirement to have an election. However, you do need at least 20% of the eligible voters to cast a ballot in the election. Elections are determined by a plurality of the ballots cast, not by cumulative voting. So if, for example, I'm a condominium unit owner, my unit has one vote, the board is comprised of 3 directors, and there are 5 candidates. So there's going to be an election. My one vote, I can cast one vote for up to 3 of the candidates. So I can have one vote for Johnny, one vote for Sally, one vote for Billy. And whoever gets the most votes wins the election. All of our ballots, sign-in sheets, voting proxies, and any other papers that relate to voting by unit owners have to be maintained for at least 1 year from the date of that vote. And if it's pertaining to an election, that next election, perhaps if you have longer than 1 year terms or staggered terms, what have you. And we'll discuss more about the official records momentarily. Any challenge to that election process has to be commenced within 60 days after the election results are announced. There's kind of like a 60-day in, 60-day out. So 60 days from the election, you have the ability to make an election challenge. In between that time, if you have an issue with who's on your board, you can only do a recall. And you cannot do a recall more than within 60 days before an election, because at that point you're going to have an election. So, your demarcation is that election date, 60 days in, 60 days before. You have certain limitations on what you can do pertaining to that election. So our candidates, who are these people? Well, a candidate is any eligible person who has timely submitted written notice of their intent to be a candidate. Again, it's that 40-day period. They have 40 days, up until 40 days before the annual meeting, in order to provide their written notice of their intent to be a candidate for the board. A person who wants to be on the board has to be eligible to be a candidate for service on the board as of the deadline for submitting their notice of intent to run, in order to have their name on the ballot and in order to serve on the board. A person who's delinquent in the payment of any assessment due to the association as of that deadline is not eligible to be a candidate. A person who has been suspended or removed by the division under the Condominium Act is also not eligible to be a candidate. A person who's been convicted of a felony or was convicted of a felony of an offense in another state, which would be considered a felony in this state, is not eligible for board membership unless they've had their civil rights, like their right to vote, hold public office, serve on a jury, restored for at least 5 years as of the date that they seek election to the board. If the person gets on the board and it's later determined that the board member wasn't eligible for board membership due to having convicted a felony, the validity of any action that was taken by the board while that person was on the board is not going to be affected. If there's a criminal charge pending against an officer or a director, such as forgery of a ballot, theft or embezzlement of association funds, obstruction of justice, then that person cannot be appointed or elected to a position as an officer or director of any association and cannot have access to the official records of any association unless it's pursuant to a court order. Now, as you heard me mention before, with the second notice of the annual meeting, you would be including envelopes. And the reason for including the envelopes is because we have voting by secret ballot. The proxy, whether it be a limited or general, cannot be used in the election of board of directors in a resident condominium. It has to be cast using a double envelope system. So we have our election ballot, we mark our election ballot, then we put our election ballot into a ballot envelope. This we refer to as our inner envelope, right? We seal our inner envelope, we don't put any markings on it, and then we put it into our outer envelope. We seal the outer envelope. The outer envelope is what gets sent to the association. And it'll have on the exterior the name of the voter, the unit or unit numbers that are being voted, and a signature for the person who voted. Inside of that outer envelope, you can have multiple inner envelopes. So, for example, let's say I own 2 units. In one outer envelope, I can vote both of my units, but I have to ensure that the ballot for each unit is in their own inner envelope. Okay, so if your inner envelope has more than one ballot, your vote's going to be disregarded. All right, but you can have one single outer envelope. Just need to indicate on that outer envelope what units are being voted with that envelope. The voter has to sign the exterior of the envelope in the space that's provided and can either mail or hand deliver their ballot to the association. Once it's received by the association, the ballot cannot be rescinded or changed. And a unit owner cannot authorize any other person to vote their ballot. Any ballots improperly cast are invalid. If a unit owner violates this provision, they can be fined by the association. However, a unit owner who needs assistance in casting their ballot for disability, maybe they're illiterate, they can obtain such assistance. All right, so here we are, we're on the annual meeting date. We've gotten a bunch of votes. Now we need to verify the outer envelopes. The verification can be done either before the meeting or it can be done at the annual meeting. The association can verify the envelopes, again, before by an impartial committee. That's done on the same day of the annual meeting. Has to be open to all members, noticed like a board meeting. And the impartial committee is going to be looking at the outer envelope, comparing it to the list of eligible voters, making sure that they have their signature and unit identification on the outer envelope, and then they check off the voter as having voted on that list. Any envelope that doesn't have that signature has to be marked as disregarded, and any ballots in that envelope are not counted. However, you want to be sure that you're saving that information, that ballot, the disregarded ballot, because it has to be maintained as official records of the association. If you don't do the beforehand process, you do have to end up verifying the outer envelopes at the annual meeting. I think a lot of associations like to dispose of having to do all of that work at the annual meeting by having this meeting beforehand, particularly with our larger associations, because it does take quite a bit of time. There were some laws enacted fairly recently pertaining to fraudulent voting activities. A person who engages in a fraudulent voting activity related to an election, like using threats, bribery, or intimidation, commits a first-degree misdemeanor. And forgery of a ballot envelope or voting certificate that's used in a condominium association election is punishable as a third-degree felony. Now, as I mentioned, doing the envelope system for our larger condominium associations can take quite a long time, and can be cost prohibitive or cost intensive, I should say, for a lot of associations, particularly if they're larger, because we have to produce the envelopes and mail everything out. And I think we actually just got a notice in our firm that uh, postage rates have increased. So it's getting more expensive to send things via mail. Well, thankfully, the Florida legislature several years ago adopted the ability for the associations to implement electronic voting through an online voting system. Now, in order to use the online voting system, the board has to first adopt a particular resolution that provides that owners will receive notice of the opportunity to vote through an online voting system and establish reasonable procedures and deadlines for owners to opt in or opt out of online voting. And then the owner actually has to opt in writing to participate in voting online. Once an owner votes electronically, they're counted as being in attendance at the meeting for purposes of determining a quorum. So when they're voting through this electronic voting system, it helps associations obtain quorum as well as with the voting process. If the online voting is used, the association does have to provide each owner with the ability to authenticate their identity, ensure the secrecy and integrity of election ballots, and to confirm at least 14 days before the voting deadline that their device can communicate with the electronic voting system. Now, the voting system that's used has to be able to authenticate the owner's identity, the validity of each electronic vote, to ensure that it's not altered in transit. It has to be able to transmit a receipt to the owner after they've cast the online vote, permanently separate any authentication or identifying information from their election ballot. Again, we need to ensure that the ballot is secret, and to store and keep electronic votes accessible to election officials for recount, inspection, and review purposes. Now, there are a lot of different services out there that do provide the online voting system in compliance with those statutory requirements. And typically, the cost is fairly reasonable, and it depends on the size of your association and how often you guys actually have membership votes. For some associations, they only have one vote a year, and that's their election. For other associations, they're much more active. Maybe they're doing material alterations, which Andy will talk about, which would require membership votes or maybe even amendments to their governing documents, what have you. So if the board authorizes online voting, then the first notice of the date of the election, which we just talked about, that's at least 60 days prior to the date, they have to disclose the procedure and deadline to consent to electronic voting. So you want to be sure in that first notice, if you have online voting, that you're putting in there the information for owners to be able to consent to electronic voting. If the board authorizes online voting, then the board has to honor a unit owner's request to vote electronically at all subsequent elections unless the owner opts out of online voting. And a vote of the owners cannot be taken on any issue other than what's been provided in that electronic ballot if the quorum is established based on owners voting electronically. So there is that. It is nice that you're able to establish quorum via electronic votes through an online voting system. However, if you have done it that way, your vote is going to be restricted to whatever's been provided on that electronic ballot. If at least 25% of the voting interests of a condominium petition the board to adopt a resolution for electronic voting for the next election, then the board has to hold a meeting within 21 days after receipt of that petition to adopt the resolution. And the board must receive the petition within 180 days after the date of the last scheduled annual meeting. So as I mentioned before, it's really a two-part process to establish online voting through, electronic voting through an online voting system. It's a board resolution, then owner consent. Well, owners who want to have electronic voting can force the board's hand with this new law. Now, with new laws, sometimes we get great changes like the adoption of electronic voting through the online voting system. And sometimes we get things that don't make sense or maybe not so favorable for associations. And I think that this is one of them. And I think it's something that needs to be cleared up for associations, for condominium associations, because there are a lot of pitfalls that could happen with these electronic ballots. So if your association does not have electronic voting through an online voting system, then the association has to designate an email address for the receipt of electronically transmitted ballots. An owner can electronically transmit a ballot to that email address without complying with the rules providing for the secrecy of ballots, so long as the owner does these few little things that we'll discuss in the next slide. And it's transmitted to the association no later than the scheduled date and time of the meeting during which the matter is being voted on. There's going to be a rebuttable presumption that the association reviewed all the folders associated with that designated email address to receive ballots if the director, officer, or agent of the association, which could be the manager, provides a sworn affidavit attesting to the review. Now, when the owner sends the ballot via email, they do have to provide their name, unit number, and the statement waiving the secrecy of your ballot is your choice. Uh, and if they don't meet these particular requirements, then the ballot doesn't get counted. Now, what's strange about this is that it's the statute that was put into place isn't specific as to elections. However, everything that they're discussing, like the secrecy of balloting, requiring a signature for the ballot, which is done by just providing your name, all leads us to believe that this is applicable only to elections. And that is generally our stance on it, that it's only applicable to elections. Otherwise, owners have the ability to vote via limited proxy, and limited proxies can be scanned and emailed. So they still have the ability to vote by email by providing their limited proxy. Whereas with an election, they didn't have that option unless your association had electronic voting through an online voting system. So not only now can owners force the board to use an online voting system, but they also have the ability to vote electronically by email. What's interesting too is that the statute makes the requirement on the association to provide all this information in an electronic ballot. But what's not clear is that the association has to send everyone an electronic ballot, or is it on the owner in order to comply with these requirements? So there are lots of little different things that are problematic with the email ballot system. Also, there's no verification of like email address. We just have to trust that the email address that's being sent is in fact the owner. So there are a lot of issues I see with this email balloting system. Well, not system, with this email ballot option for owners. Okay, so we've discussed our board and how they get onto the board. Now let's talk about our officers. So unless otherwise provided in your bylaws, the board has to have a president, secretary, and a treasurer who perform the duties that are customarily performed by the officers of those corporations. And a lot of times your bylaws will provide some specific duties. Your bylaws can also provide for other officers. Maybe you have a assistant secretary, or maybe you have a vice president requirement. So definitely be looking at your bylaws for that. Unless prohibited by your bylaws, the board can appoint other officers and grant them duties as it deems appropriate. And the officers serve without compensation and at the pleasure of the board, unless your bylaws would provide otherwise. Generally, officers are selected by the board immediately following the election of the directors at a board meeting that's often referred to as the organizational meeting. Directors cannot vote by proxy or by secret ballot at board meetings, but they can use secret ballots to elect their officers. And there's no prohibition against changing officers mid-term. So if you come across an issue with your treasurer, well, the board can hold a board meeting and then change their treasurer mid-term. An officer or director who knowingly solicits, offers to accept a kickback commits a third-degree felony and is subject to a civil penalty. When we read civil penalty, what they mean is monetary fine, and must be removed from office and a vacancy declared. Now, what is a kickback? Well, I'm sure a lot of people have heard the term and understand its meaning, but there is a definition provided. It's anything or service of value for which consideration has not been provided for that person's own benefit or for the benefit of their immediate family, from any person providing or proposing to provide goods or services to the association. An officer or director who's charged by information or indictment for any crime that's outlined in this particular statute, which would include forgery of a ballot, theft or embezzlement of association funds, obstruction of justice, for example, they're removed from office. And if the charges are resolved without a finding of guilt, then they must be reinstated for the remainder of the term if there's any term left. A director or officer who's more than 90 days delinquent in the payment of any monetary obligation due to the association is deemed to have abandoned their seat. A vacancy is created, and then the vacancy gets filled by the board. A director who willfully and knowingly or intentionally violates the official records inspection requirements, again, we will discuss official records momentarily, commits a second-degree misdemeanor and has to be removed from office and a vacancy declared. Any person who knowingly or intentionally defaces or destroys accounting records specifically, that are required to be maintained during the period for which they're required to be maintained, or who knowingly and intentionally fails to create or maintain those accounting records with the intent of causing harm to the association or to any of its members, commits a first-degree misdemeanor and is subject to a civil penalty and must be removed from office and vacancy declared. A person who willfully and knowingly refuses to release or otherwise produce association records with the intent to avoid or escape detection, arrest, trial, or punishment for the commission of a crime or assists another person to do so, commits a third-degree felony and must be removed from office and a vacancy declared. If this sounds like a lot of criminal charges for things that could happen on your volunteer board, there are. And there are more, but I promise this is the last one. A person who uses the debit card issued in the name of the association or billed directly to the association for an expense that's not a lawful obligation of the association commits theft and must be removed from office and a vacancy declared. Now, a lawful obligation of the association means an obligation that has been properly pre-approved by the board and is reflected in the meeting minutes of the written budget. Now, if the board finds out that an officer or director has violated the conflict of interest requirements, the officer or director is deemed removed from office, creating a vacancy to be filled according to law. Conflict of interest, meaning like you have a financial interest, either directly or through a company that you maybe own or are financially interested in, didn't disclose it, wasn't a fair bargain, something like that. I think Andy will go over conflict of interest in the second portion. Anyway, excuse me, a director who fails to timely file the written certification and educational certificate is suspended from office until they comply with the requirement. The failure to have the written certification and educational certificate on file does not affect the validity of any board action. But it is a suspension, not you get kicked off the board and a vacancy is declared. You just can't operate on the board until you comply with the requirement. Now, once you're done with this particular course, you take your evaluation, you wait your 10 business days to get your certificate. That only satisfies half of your certification requirement. You also do need to comply with the written certification portion of it. There is a form on the DBPR's website for that written certification. You can download the form, fill in the information, sign it, and make sure you get it to your secretary. Like I said, the DBPR's website, the division's website, has a lot of great resources for condominium associations in particular. Now, I know I keep teasing it, the Condominium Association website requirements, so let's get right into it. All right. So, if your condominium association has 25 or more units, you are required to have a website. Your website has to be an independent website or web portal that's wholly owned and operated by the association, or it could be a website or web portal that's operated by a third party with whom the association owns, leases, rents, or otherwise obtains the right to have that web page or portal. So a lot of associations, maybe host their website through the management company or something like that.
Hey Danielle, can I just interject because this is going to come up in the Q&A by dozens of people. It always does. When Danielle mentions website or portal, consider that to be synonymous in terms of what's going to fulfill the requirement. And anybody who refers to it as a portal, let's say you have an existing website already. All right, you have something that's showcases your amenities. It's not something that you have to log in to see. You have something showing off your community. So you could just go ahead and add a portal to it. And by portal, all that really means is something that you would log in with so that only certain people can see the requirements that are not public record. So I just wanted to clarify because that's going to come up in the Q&A. I know it will. It always does.
Right. So there does have to be a portion. So if you have a website like
Whatever.com.
www.shinyvillascondominium.com, you go to your home page, you have a landing page there that the public can see. But there has to be a section of your website that is protected by username and password that only your members can
Right.
have access to.
Right.
Okay. So that's
Thank
what
you.
Jeff is talking about. No problem. So you do have to have that protected area. Once an owner requests it, the association has to provide that username and password so that they can access the protected portions of the association's website. Now, through that protected portion, you're going to be posting certain official records of the association. What records, you ask? Well, I'm so glad you all asked. It's this long list and litany of different official records. Believe it or not, this is only a portion of the official records that have to be maintained by the association. So you have to post your recorded declaration of condominiums, your bylaws and all amendments to those, your articles of incorporation as they're filed with the division of corporations, or other documents that create the association and all amendments to those, the current rules of the association, a list of all executory contracts or documents to which the association is a party or under which the association or unit owners have an obligation or responsibility. And if they were bid after bidding for those contracts has closed, then a list of the bids that are received by the association within the past year. Now you can have summaries of the I'm sorry, you can either have summaries or post complete copies of the bids. Summaries of bids for materials, equipment, or services that exceed $500. And if it exceeds $500, then you can post the whole bid. Not a big deal. Does have to be provided on your website for 1 year. Your annual budget and any proposed budget that's considered at the annual meeting, which is an interesting statement considering that most associations' annual budgets are adopted by the board and they're not adopted by the members at the annual meeting. So that's a strange requirement, but at any rate, it's there. The financial report and any proposed financial report to be considered at a meeting. The excuse me, I can't speak. The certification of each director. All contracts or transactions between the association and any director, officer, corporation, firm, or association that's not affiliated with the Condominium Association, or any other entity in which an association director is also a director or officer and financially interested, and any contract or document regarding a conflict of interest or possible conflict of interest. So perhaps there is a contract that the association has entered into with a director's corporation. So you would post that contract, and let's say the director disclosed the conflict in writing. You would also be posting that written conflict disclosure on the website. Notice of any board meeting, which has to include an agenda and any other document that's required for that meeting, must be posted no later than the date required for the notice. Andy will go over this more later, but typically board meeting notices have to be posted 48 hours in advance of the board meeting, unless it's pertaining to a non-emergency special assessment or a rule regarding unit use. Those notices have to be sent to and posted to the owners 14 days in advance of the meeting. So that's, your typical time frame there. Let's say you are going to be adopting rules regarding unit use. Then you would post both the board meeting notice and agenda and a copy of those proposed rules on the association's website at least 14 days before the board meeting. Also, for our membership meetings, you do have to post them on the association's website at least 14 days before the meeting. This does have to have a conspicuous posting, either on the landing page, whatever that plain view, or on a separate subpage of the website that's labeled notices, which is conspicuously visible and linked from that front page. The association does also have to post any document that's going to be considered on it and voted by the owners at the meeting, but it's a 7-day requirement, not a 14-day requirement. I'm not sure why the distinction is made, but it is. So let's say the association's members are going to be voting on an amendment to their declaration. You would be posting the notice and the proposed amendment on the association's website. As I mentioned before, when we were discussing the CEUs, you do have to post the most recent CEUs, as well as any inspection reports that are related to the structural or life safety inspection of the condominium property, like your milestone inspection, like your 40-year recertification, inspection, whatever, what have you. Copies of all building permits that are issued for ongoing or planned construction. A copy of all affidavits that are required by Chapter 718. So like your, maybe like your affidavit of mailing or, what other affidavits do we have? I can't think of them off the top of my head. But whatever affidavits are required by Chapter 718 will need to be posted on the association's website. And the approved minutes of all board meetings that are held over the preceding 12 months do have to be posted on the website. Now, the failure to post these documents on the website do not in and of themselves invalidate an action or decision of the association. The association has to designate on its website a person or entity with a street or email address for the receipt of a request for an estoppel certificate. And Andy will discuss more of those financial fiscal matters that are handled by the association in his portion of the presentation. The association has to ensure that the information and records that are not accessible to unit owners are not posted on the association's website. Which records are those? We will discuss. If protected information or information that's restricted from being accessible to unit owners is included in documents that have to be posted on the association's website, then the association has to redact that information before posting them on the association's website. However, in complying with the posting requirement, there's no liability for disclosing information that is protected or restricted unless the disclosure was made with a knowing or intentional disregard of the protected or restricted nature of such information. So if you see the information, you know it shouldn't be disclosed, and you say, you know what, I don't care, I'm going to disclose it anyway, then there's liability attached to that. Instead of posting the documents on a website, the association can have an app. I have yet to see an association that has like a mobile app, but that would be pretty cool. The downloadable app must meet all other requirements that are imposed on a website. So it would be the same thing. All right, so as promised, official records. Here we go. The official records are composed of essentially all written records of the association that relate to the operation of the association. So, plans, permits, warranties that are provided by your developer, all of your governing documents, including the declaration, articles, bylaws, amendments to those governing documents, meeting minutes, roster of all unit owners, um, insurance policies, financial records, accounting records, um, management agreement, current question and answer sheet. Your question and answer sheet. People see that and they're like, what the heck is a question and answer sheet? Well, pursuant to Florida statute, you are required to have and annually update a question and answer sheet. The form is available where you guessed it on the division's website. So make sure you're going on to the division's website, pull the form, fill out the form, make sure it's updated annually because you're required to do that. Um, there's another list coming. So let me focus on the ones that are here. With regard to the roster of all unit owners, it has to include their mailing address, unit identifications, and voting certifications. If your association requires the designation of a voting member, that's what they're referring to there as a voting certification. And if known, telephone numbers. Now, the association must also maintain and make available for inspection the email addresses of those owners who either consent to receive notice of association meetings via email or expressly indicate that their email can be shared with other owners. So when an owner is providing their consent to receive notice via electronic transmission, that email address is accessible to other owners. All right, so I just want to draw that out for everyone. Emails can only be used for the business operation of the association, and you can't sell them or share them with outside parties. Let's see here. As promised, there's a list, a second list here. All of your educational certificates, the certificates that you get after this presentation, when you fill out your evaluation form, you wait patiently your 10 business days to get your certificate. That certificate that you receive is part of the official records and has to be posted on the association's website. Any approved minutes of all board meetings or the preceding 12 months, any video recording or a hyperlink to the video recording for all meetings of the association, board, or committee, or the owners that is conducted by video conference. So there is the ability to conduct meetings via video conference. I'm sure Andy will cover this in his portion. But if you hold a meeting via video conference, it has to be hybrid, meaning you still have to have a physical location, and you have to record those meetings. The recording is an official record of the association and has to be posted on the association's website. Affidavits required by Chapter 718, again, official records have to be posted on the association's website. And there's this catch-all, as I mentioned before, written records of the association that relate to the operation of the association. Now, all official records have to be maintained for at least 7 years. However, records that must be permanently maintained include the plans, permits, warranties, and other items provided by the developer, your declaration, bylaws, all amendments to those, a certified copy of the articles of incorporation and all amendments to those, a copy of the current rules and all meeting minutes. As mentioned before, your structural integrity reserve study, inspection reports, they have to be maintained for at least 15 years. Bids for work to be performed or for materials, equipment, or services have to be maintained for at least a year after receipt. And ballots, sign-in sheets, voting proxies, other papers related to voting, electronic records related to voting have to be maintained for at least 1 year from the date of the vote, or longer if you're, for example, have 2-year staggered terms. The official records must be maintained in an organized manner that would facilitate inspection of records by unit owners. And if official records are lost, destroyed, or otherwise unavailable, then the association does have to put forth a good faith effort to obtain and recover those records as is reasonably possible. what exactly that means for an association, it remains to be seen. But to use commercially reasonable efforts, you don't want to be spending a fortune on trying to obtain records, but you do need to try. After receipt of a written request by the board or its designee, the official records have to be made available to an owner and the owner's authorized representative within 10 business days and within 45 miles of the condominium or within the county in which the condominium is located. Now, renters do have the right to certain records, but it's way limited, only to the declaration of condominium, the bylaws, the rules, and their inspection reports. Otherwise, it's just an owner right. The association can comply with the inspection requirements by having a copy of the official records available for inspection or copying, like having a copy like physical records, offering the option to make the records available via the internet. And if the association's records are available on the website or app, the association can simply direct the owner to the website or to the app. Or the association can allow the records to be viewed in electronic format on a computer screen and then printed upon request. Perhaps, you have their server there on location. They can come and view the records on the association's computer. The right to inspect the records includes the right to make or obtain copies at a reasonable expense, if there's any expense of the member. The association has to allow the use of a portable device like your iPhone, like a scanner, and I've actually had someone bring a full-on printer scanner combo to an inspection, plug it in and make their scans. They get to do that free of charge. So he sat there and he scanned everything in. It was pretty incredible. The association must maintain an adequate number of copies of the declaration articles, bylaws, and their amendments and the current rules, the question and answer sheet, there she is again, and year-end financial information on the condominium property to ensure their availability to unit owners and prospective purchasers, and can charge the actual costs for preparing and furnishing those documents. Now, what is adequate will ultimately depend on the size of your association, your condominium, how many units you have, but having a handful on hand is useful. The inspection and copying checklist is a fairly new requirement. In response to an official records request, the association has to simultaneously provide a checklist of all records made available for inspection and copying, and must identify any of the official records that were not made available to the requester. This checklist has to be maintained for 7 years. And the association delivering the checklist pursuant to this requirement creates a rebuttable presumption that the association complied with this obligation. Now, an association can adopt, and I certainly advise that associations adopt reasonable rules regarding the frequency, time, location, notice, and manner of record inspections and copying. However, the association cannot require an owner to show any proper purpose for the inspection or state any reason for the inspection. As I mentioned before, there are records that, although they are official records of the association, are not accessible to members for inspection and copying. These records include records protected by the attorney-client privilege or the work product privilege, information obtained by the association in connection with the approval of a lease, sale, or transfer of a unit. Perhaps your association's declaration provides the association with the authority to screen and approve tenants or purchasers. The information that you obtain, like a consumer report, would be inaccessible to owners. Personnel records of the association or its management company. However, personnel records does not include written employment agreements with the association's employee or management company, or budgetary or financial records that would indicate how much that person is being paid. Medical records of unit owners, and some of you might be saying, we're a condominium association, why would we have medical records of unit owners? Well, we got to think about the Fair Housing Act and the ability for residents to have emotional support pets, assistance animals, service animals, in which the association may come into possession of medical records of owners. Any electronic security measures that are used by the association to safeguard data, including passwords and any software and operating system that's used by the association, which allow them to manipulate data, like Microsoft Word, even if the owner owns a copy of that same software. All affirmative acknowledgments. This is having to do with providing invoice statements. And Andy may talk about this in his portion about fiscal management of the association. Social security numbers, driver license numbers, credit card numbers, email addresses, telephone numbers, facsimile numbers, and emergency contact information, and addresses of a unit owner other than as provided to fulfill association's notice requirements. Again, email addresses for those owners who have provided their consent to receive notice via email are accessible to owners. What is also accessible? Person's name, their unit designation, mailing address, property address, any address, again, email address, fax number that's provided to fulfill the association's notice requirements. Now, there is a caveat here for those associations that print and distribute a directory containing the name, unit address, and all telephone numbers of each owner. However, the owner can exclude their telephone numbers from the directory by written request to the association. And it's important to note that the association is not going to be liable for an inadvertent disclosure of this information if it's been provided in an official record voluntarily by the owner and wasn't requested by the association. For example, an email address. Let's say an owner has not provided their consent to receive notice via email, but the owner sends an email to the association's manager about something. Well, that email is going to be part of the association's official records, and it has that person's email address on it. So if somehow the association doesn't catch it, doesn't redact it, and an owner gets access to it, well, then that inadvertent disclosure isn't going to impart any liability onto the association. Again, pertaining to records not accessible to members, the member always has the option to provide written consent to the disclosure of their information. I don't know how often that actually occurs, but it is a viable option. The association has to ensure that the records that are not accessible to unit owners are not posted on the association's website or app. This is just review. If protected or inaccessible information is included in a document that must be posted, you have to redact it. The association or its agents not going to be liable for disclosing protected or inaccessible information unless the disclosure was made with a knowing or intentional disregard of the protected nature of that information. And the association is not going to be responsible for the use or misuse of information provided to a member or their authorized representative when complying with the official records requests, unless the association has an affirmative duty not to disclose that information to the owner under the Condominium Act. Now, it provides a little definition of the attorney-client privilege. Suffice it to say that communications between the association's lawyer and the board are privileged communication unless the board votes to waive that privilege. So the association's attorney does not hold the privilege. The privilege is held by the board, and only the board can waive that attorney-client privilege. Now, let's say the association receives a written request to inspect and copy official records of the association from an owner. The association has 10 business days to provide access to the association's official records for inspection and copying. The failure to do so creates a rebuttal presumption that the association willfully failed to comply with the requirement. A unit owner who's denied access is entitled to actual damages or minimum damages, being $50 per day up to 10 days, which the calculation begins on the 11th working day after receipt of that written request. The failure to permit the inspection entitles any person that prevails in an enforcement action to recover their reasonable attorney's fees from whoever was in control of the records, who directly or indirectly knowingly denied access to the records. So this is a personal liability here. The director or manager who willfully and knowingly or intentionally fails to provide access to the official records commits a second-degree misdemeanor and must be removed from office. Again, we're talking criminal penalties here. The refusal to allow the inspection or copying of any official record that's accessible within the time periods required by law in furtherance of any crime is punishable as tampering with physical evidence or as obstruction of justice. Again, criminal offenses here. Any person who willfully and knowingly or intentionally defaces or destroys accounting records, this is a review again, that are required to be maintained, or who willfully and knowingly or intentionally fails to create the records, the accounting records that are required with the intent of causing harm to the association or any of its members, commits a first-degree misdemeanor, subject to civil penalty, and is removed from office. A person who willfully and knowingly refuses to release or otherwise produce records with the intent to avoid escape, detection, arrest, trial, or punishment for the commission of a crime or assists another person to do so commits a third-degree felony and must be removed from office. And the destruction of an official record in furtherance of a crime is punishable as tampering with physical evidence or as obstruction of justice, as we just mentioned. And finally here, an outgoing board or committee member has to turn over all the official records and property of the association in their possession or under their control to the incoming board within 5 days after the election. One who does not, who willfully and knowingly fails to do so is subject to a civil penalty that's imposed by the division. And here we're talking about the division of Florida condominiums, timeshares, and mobile homes. And that will do it for me.
Yes, ma'am.
I don't know if Andy's here.
Andy is here. He's on deck. He's in the
I hear
bullpen.
it. Let me
And
stop.
before we get to the next section, Danielle, do you want to take one or two questions, and Andy will
Let me see.
take whatever
I have to
time we
look.
have left at the end for the rest of them. And while you're looking at that, I just want to reiterate to everybody, any course related questions, please put them into the Q&A module, not the chat module. Okay, two different modules. Don't write a novel. We're going to skip right through those. So keep them short and sweet and on topic. And another reminder is that the chat module is where you can pose technology or other issues, questions for me that don't require an attorney's answer. That's also where we're going to place the link for the required post-webinar form at the end of the class. Danielle, you want to take a couple?
Okay, sure.
And now's a good time for a quick bio break, folks. If you want to walk away for 2 minutes and come on back, now's the time to do it.
Are board election voting and general voting treated the same as in the electronic voting rules, etc.? Yes. I think what you're asking is if the association has online or has electronic voting through an online voting system, is the vote handled in the same way through that system for an election or for any other vote? And the answer to that is yes. The electronic voting requirements are the same regardless of what the vote is. Can it be that a mother and son can be a board president and vice president when they live in a separate apartment in the same condominium? Yeah, I mean, there's nothing in the law that would prohibit that. Can a board president with, oh, what happened? Okay. Can a board president and
He clarified in the next. He said you meant to say wise instead of with, and that second. So can a board president and I guess who's also a wise president can this person confirm a two
oh,
hundred thousand
vice.
dollar?
He means vice.
Oh, vice. Okay, I
I
saw
think that's what he
wise.
means. Okay,
Okay.
can a board president with and vice president confirm $200,000 plumbing job without board member vote? You know what? It really depends on the circumstances. We know that association board members and officers, let's say, officer and director, they're not the same role. You're referring to officers and the board. So presumably in your association, your officers also happen to be board members. That's not always the case. So we know that officers and directors cannot unilaterally act without having some kind of authorization from the board. So perhaps there was something that was approved by the board previously that allowed them to do this. Maybe it was under emergency circumstances. There's so many different things that could possibly come into play with that. I guess someone's asking about their authority to sign checks for the condominium. A lot of times in your bylaws, they'll provide who can make withdrawals, who can sign checks for the association. What if 20% of eligible voters do not cast a ballot for it to be a valid election? So if you don't have enough ballots cast to hold an election, you're going to end up having a rollover.
Let's do one more, Danielle, then we'll get Andy to come on in and get started.
Okay. Where can we find the electronic voting system? So as I mentioned before, there are a lot of different online voting systems available. There's like Vote HOA now. Get Quorum is a big one.
There's a bunch. Building link.
Vote Now, Jeff may know some more. Reach out to your management company. They probably work with a lot of the people from the different vendors out there. Go to a trade show. Usually they're there too. We do them in
CAI.
person all the time. Yes, and there are a lot of resources out there. You can also use Google. They're out there advertising, and they want your business. So
Yeah. And I'm going to say there, it's not difficult to build a website these days. So you might be thinking as a manager or a non-affiliated manager or a board member saying, hey, I could just go on our website and do it ourselves. Well, as the firm's resident nerd and geek myself, that's not a great idea to do because algorithms are always changing. Your operating systems are always changing, and there are privacy issues when you do this online voting thing. So you're asking for trouble if you try to do something like that yourself. That's why all these vendors out there are successful at what they do. That's all they do.
all right.
All right.
Um,
Thank you so much, Danielle. As always, wonderful job.
Thank you, guys.
Thanks, Danielle.
Bye.
Take care.
And over to you, Andy.
What timing? Perfect timing.
So we're gonna go down the state a bit from Palm Beach Gardens over to our Pompano Beach office. And I mentioned earlier there are very few attorneys in the state of Florida that have the board certified specialist designation in condo and plan development law. And today we have two of them. So now let's go to our second presenter for today from our Pompano Beach main branch of K. Bender Rembaum. This is Andrew Black. Andrew, welcome. Good morning or good afternoon.
It's good afternoon, Jeff. Thank you so much. It is 5:02 on a Friday afternoon. I don't know where else you all would want to be, but smack dab in a 4-hour board certification course. But I know you've learned a lot so far, and I'm going to take the home stretch here. And Jeff, I do have to share the outline, correct?
Yeah, the slides, and I've got them ready. If you don't, just let me know.
Yeah, give me 1 second. This
Sure.
is my favorite part. I've only done this 149 times.
150 coming up. So
$150.
While Andy's doing that, just a reminder that I see some of you are still posing questions in the chat module for course-related questions on the material that Andy and Danielle are presenting today. Please use what is called the Q&A module. The chat module is where you can pose technical questions like, hey, Jeff, I can't hear, I can't see the slides. When's your next class? Things like that, things that don't require the ESQ to be after my name. I can take those questions in the chat, but any course-related material questions, please use the Q&A. Andy, back to you, sir.
Awesome. Thank you very much. And again, I am super excited to be here with you. We do have a few topics to go over. And my style is, and hopefully you'll find it somewhat interesting, is that I'm not going to be reading line by line every slide, right? I want to try to focus in on some of the primary things that we see as a law firm that our property managers come to us with. Certainly, if you're on your board, which I'm sure most of you are right now, or you're thinking about it, I want to focus on those topics. But there is a lot of substance here. So the first topic, topic 3, is really dealing with financial types of matters. And the first one I just want to spend a minute on is right on slide 96. This is transfer fees. This is talking about when your association has a sale or lease review process. All right. And if you're thinking to yourselves, oh, we do review and approve people that want to buy or people who want to rent, you may be aware of, you charge a transfer fee. Some people call it an application fee. Per statute, and again, I'm talking about Chapter 718, per statute, in order to charge a transfer fee, your governing documents, either your declaration, articles, or bylaws. So either your deck, articles, or bylaws must have the authority to charge that transfer fee. I can't tell you how many times I've reviewed governing documents. The transfer fee authority is not there. And boards come to me and say, how could that be? And, there can be a wide range of answers for that. But the bottom line is, if you want to avoid any possible legal challenge, make sure your deck, articles, or bylaws contain that transfer fee authority. Per statute, if you have that authority, the max is $150 per applicant. Okay. So be aware of that. Obviously, we put some language in red font there. The $150 per applicant, other than husband, wife, or parent dependent child, they're considered one applicant. So if it's a husband and wife applying, you cannot charge them $150 each. It's $150 total. So that's transfer fees. Another common financial sum that is charged is security deposits in connection with the lease approval process. Okay. Similar to a transfer fee, the authority to charge a security deposit must be in your deck or bylaws. If your deck or bylaws don't mention the ability to charge a security deposit, guess what? You don't have that authority to do so. And if you do, you're subject to a possible challenge. We can't predict whether someone would challenge it or not, but it's important that the board, and certainly if there's your property management, is aware of that. Let's say your deck or bylaws, and usually the deck is the more appropriate place for it, but let's say your documents authorize a security deposit. Very important. It is refundable. Okay. It shouldn't be thought of as income to the association. It's refundable, and it should only be used to offset damage that the tenant causes during his or her lease agreement. If there's no damage at the end of that lease agreement, you have to return the security deposit. And there's time frames within what's called the landlord tenant statute. It's in Chapter 83. Okay, a security deposit, you're essentially holding it as if you were a landlord. So again, if there's no damage, you got to return the security deposit. If there is damage, there's a statutory form that must be followed to notify the tenant of the claim and the amount that you're making on that security deposit. So again, be aware of that. If you maintain security deposits, they should be accounted for so you know exactly what's there. And again, it's not income. It's an amount that there must be a claim made, or it must be return. And again, there's time frames to follow. There's a handful of slides, almost 6 of them, dealing with estoppel certificates. I don't know about you, but 6 slides is plenty on estoppel certificates. But I think it's important to highlight just a few points. First is, what is an estoppel? I'm sure you all have heard that phrase. Your property management company usually handles the process when typically it's a title company will make an estoppel request. What they're asking for is this is done in connection with a sale. And essentially, the buyer wants to know some information, primarily what monies are owed. How much does the current owner owe? Basically, what am I walking into? So it is crucial, whatever representative of the association, whoever's filling out the estoppel certificate, they must make sure they have updated account ledger information and that you accurately reflect what monies are owed and what monies will be due in the future, right? Because if you list an incorrect amount that's owed and the sale is completed, closing happens, that new owner could very well have a strong defense against the association when you try to collect those funds. The owner can say, you put an incorrect amount on this estoppel. I reasonably relied on that estoppel when I bought. Therefore, you have lost or waived, or you are prohibited from now seeking that full amount when it wasn't reflected on the estoppel. Okay, there's timing aspects to this as well. Right on this slide 97, when association gets a written request, you have 10 business days to issue the estoppel certificate. Okay, this slide, the next two, this is right from the statute. And this outlines exactly what the contents of the estoppel certificate must be. And it's common sense stuff. It's really information that the new buyer is entitled to know and wants to know. Okay. So whether they're assigned a parking space, how much the fee is for the estoppel certificate. This on slide 99, this is the financial aspect, right? What are the regular assessment amounts? When's the next installment due? Are there special assessments due? Okay, this is all the content of the estoppel certificate. And finally, slide 100 again. This is still what the estoppel certificate must show. I just want to point out one to you, number 2, where it says whether there's any open violation. Okay, this is basically letting the new owner know, hey, the current owner, he or she has violated the restrictions. Attached are copies of the prior violation notices that have been sent. And I think it's important, if there are open infractions on the file, make sure that they're indicated on the estoppel. Okay, so the last 3 slides were really what the content is. This slide here, everyone wants to know how much can we charge for these things. And I think it's a good idea to be aware of that. If the unit is current, right, they don't owe anything, it's a $299 charge. If the unit is delinquent, they're past due, you can tack on another $179. And finally, if the party requesting it says this is a rush, and that happens more often than you may think, you can add another $119 charge. So just be aware of that. Again, if you're on a board and you have a property manager or a property management company, I'm virtually certain they take care of this for you, but it's worthwhile to inquire. Okay. All right. Just kind of to point out the fees that an association can charge for estoppel certificates. That can be adjusted every 5 years by the DBPR, right? That's the state agency, the Department of Business and Professional Regulations. That's where the Division of Florida Condominiums, that's the department it's within. So the DBPR, they will post on their website any adjustment of what the maximum estoppel certificate fee is. And again, finally, I told you this is everything you'll ever want to know about estoppel certificates, but they're effective for a 30-day period if they're sent via email, which is a pretty common way. Obviously, if they're sent by mail, they're good for 35 days. This is another interesting part, and you all, I'm sure, have seen this. There's language in the statute, and the site is right here on slide 105, which says, there's other documents that sometimes title companies or a bank who's issuing a mortgage for that sale. There's other information, whether you call it a lender questionnaire, that oftentimes boards or via the association's management company is being requested to fill out. Interestingly enough, there's nothing in the law that says you have to fill out a lender questionnaire. Okay, you have to do an estoppel certificate, and we talked about what the contents of that estoppel certificate must show. But anything else, there's actually no law that says the association has to fill out a lender questionnaire. Having said that, I'm not suggesting that you don't cooperate and do it, because obviously owners are going to be very unhappy if they can't sell their units because the association isn't playing ball, right? And isn't answering these lender questionnaires. But it's important to know any other sort of questionnaire that the association fills out, you want to make sure that the sentence at the bottom of this slide, it's in italics. You want to make sure that that language is added to any questionnaire, which reads, the responses herein are made in good faith and to the best of my ability as to their accuracy. That's a good legal sentence right there, right? That's protecting the association and whatever association rep filled out the questionnaire. It's basically saying, I'm in good faith answering these. I believe what I'm telling you is accurate. But what you're not doing is you're not certifying via an affidavit that it's 100% accurate. It's good faith. Okay. So just be aware of that. And also, I think it's important to know that you can charge the requesting party, okay, up to $150 if you as an association is filling out these lender questionnaires. Okay. So I think it is a good idea to be made aware of that. A couple other topics regarding units that are being sold. Hopefully you all have heard of the condo question and answer sheet. Some people call it the FAQ, the frequently asked question sheet. That's a statutory form. There's about 7 or 8 questions that the association is actually required to answer. And you only need to have it completed because it's part of the official records. So each year you should just have an updated frequently asked question sheet. So anyone that, requested, or certainly in conjunction with the sale process, you already have it filled out. If you're not sure if you have one or if you don't have one, definitely get with your management company to inquire whether you have one. And if you don't, definitely get with your current association counsel just to assist to make sure it's completed correctly. That frequently asked sheet, it asks things like, what are the rental restrictions? What are my rights to vote? Am I required to belong to another association, like a master association? It also asks whether there's any pending litigation that the association is involved with. And it also asks about what the assessment amounts are. So the condo question and answer sheet is different from an estoppel. Okay. So you want to just make sure you're aware of that. And I believe Jeff, his timing is awesome, just shared a link that will bring you to a version of that frequently asked question sheet. Okay. Also, again, just dealing with sales, right? Sales of condo units. This slide 107, this is the obligation of the selling owner. This is what he or she must disclose to a buyer. It's common sense stuff. It's the governing documents, right? The deck, the articles, the bylaws, the rules, and this frequently asked question sheet, just like I spoke about. Okay. There's also something called a governance form. Okay. That is published by the DBPR, and sellers are required to share that. And this slide here just talks about the contents of that form, and that's also available at the DBPR site. Okay. With that, I'll take a quick pause. We're still trucking right along on topic 3. I'll try to take questions at the end of each topic. We still have a decent number of slides before we get to topic 4. All right. So now we're kind of shifting gears somewhat. We talked about some of the financial aspects and certain forms and fees an association can charge. This is dealing with enforcement rights. Okay. This is dealing with when an owner or a tenant violates your governing documents. What are some of the enforcement rights you all have? And hopefully you all are aware of the ability to levy a monetary fine or to suspend the common area use rights. And again, we're talking about when an owner violates your governing documents. Your documents don't allow commercial vehicles. John Doe brings one in. This is some of the enforcement rights you can use. A key takeaway is to fine or suspend use rights, you do not need to have the authority in your governing docs. So your documents can be silent. The authority stems from the Florida statutes. Okay. It's section 718.303. It walks you through the fining or suspension process. A very important part is, and this sometimes is a hurdle where boards feel like it's too much trouble or they simply can't find enough people to serve, is that in order to fine or suspend use rights, you do need to have an impartial committee of at least 3 owners, okay, who are appointed to fill that role. Okay, so they're independent. What does that mean? It means they're not on the board. They're not an officer. They're not related to a member of the board or related to an officer. They are independent owners. And you want to think about this impartial committee, whether you call it a grievance committee, a fining committee, a rule committee, whatever title you want to give it, they're impartial. There must be at least 3. Okay. And you want to make sure that committee has been formally established by the board. The board should hold a board meeting, notice posted 48 hours prior, with an agenda item, which is establishment of the grievance committee or whatever you want to call it. Okay. Once that committee is established, in order to fine, let's say, John Doe for having that commercial truck, the board should have a board meeting, 48 hours notice. You approve a fine against John Doe. Okay. Notice is then sent to John Doe that informs John Doe of the date, time, and location of when that committee hearing will be held. That notice must be sent at least 14 days prior to that committee hearing. Okay. So just keep in mind, in order to fine or suspend use rights, you need the impartial committee of at least 3 owners established. You must send notice to John Smith of his opportunity to attend a hearing before this committee, and that notice must be 14 days in advance. Importantly, regarding the amount of the fine, it cannot be more than $100 per violation. If it's a continuing infraction, he has his commercial truck for 10 days, you can fine John Doe $100 each day, but it cannot exceed $1,000 in the aggregate, right? So the total amount of a fine for the same infraction is $1,000. Okay, so $100 per violation up to $1,000. Okay. Importantly, a fine cannot become the source of a lien against a unit. So it's not treated like your regular assessments that you pay monthly or quarterly. It's not treated like a special assessment that the board may adopt with the proper 14-day notice. Okay, a fine cannot be treated like that assessable sum. So you cannot file a claim of lien and a foreclosure lawsuit for a fine. Now, you may be asking, so what do we do then? Well, a fine, it can stay on the account ledger as a cost, okay? And if an owner ever goes to sell, you could reflect that fine on the estoppel and try to get it at closing. Some boards think about, maybe is it worth filing like a small claims action to collect a fine? I mean, that's the business decision of the board. But, fining, again, is just one enforcement tool. It obviously doesn't get rid of the underlying infraction. I've dealt with a kind of, I don't know if it's funny, but an interesting fact pattern over here where a gentleman had a boat in his driveway. Boats were not allowed. In his mind, paying a fine was cheaper than paying storage fees at a dock, right? And he's probably not wrong. So then you may be asking, well, what's fining for? Fining is really a deterrent, okay? If fining doesn't work, it doesn't get the owner to cure what's wrong, and certainly the gentleman that had his boat, it did not. The association always has the ability to file legal action against the owner as contemplated in Chapter 718. And ultimately, that can result in actually filing a lawsuit against John Smith to seek a court order forcing John Doe to get rid of his boat or to get rid of his commercial truck, to go back to the fact pattern I was talking about before. Also, just really quick, the process to fine an owner for violating a rule, if you want to suspend their use rights, it's the same process. If they violate a rule, you want to take away their ability to use the gym or the pool, you need to follow that 14-day notice of the opportunity of the hearing in front of the impartial committee. The statute also allows a board to suspend use rights if an owner is delinquent more than 90 days. It can be in any monetary obligation. It could be an assessment or a fine, okay? So if an owner is more than 90 days, the board, you do not need to use that impartial committee process, okay? Let me repeat that one more time. To suspend use rights for a delinquent owner who's delinquent more than 90 days, that can be done through board action only. You do not need to go through that 14-day notice and utilize that independent committee. The board still needs to meet at a duly noticed board meeting, notice posted 48 hours in advance. There should be an agenda item that says suspension of use rights of units more than 90 days past due. There should be minutes of a board meeting reflecting whether the board approved that. And then certainly after the board meeting, notice of that use rights notice should be sent to every owner who has had their use rights taken away. Hopefully this is somewhat obvious, but I want to just point out the language in red font. A use rights suspension does not apply to your ability to park, doesn't apply to, access to and from your condo unit, does not apply to utility services. You can't turn off power, you can't turn off water. Hopefully these are common sense things, but if it's important enough that the statute talks about it, I think it's important enough for me to make mention of it. Another enforcement option for someone that's 90 days past due is you can suspend their ability to vote when the owners are voting on something, whether that's the election to the board, perhaps the owners are voting to amend the governing documents, or they're voting to approve a material alteration, or to use non-CEUs reserve funds for an alternative use. There could be a wide variety of owner votes, and the statute does contemplate a board voting to suspend the voting rights if an owner is more than 90 days past due. There's a couple extra things that have to be in place as well. One of them, to suspend voting rights, the past due amount must be greater than $1,000, and you must have sent proof or notice to the owner that you owe these funds 30 days before the voting right suspension takes place. I just think it's important to be aware of that. If you do suspend voting rights, it's an interesting quirk. When you do your calculation for quorum, you act like that unit is not there at all. So let's say you have 100 total units. Let's say you properly suspend voting rights of 5 of those units. When you're calculating quorum, it would be quorum of 95 units, not a quorum of 100. You subtract those units that have had their voting rights removed. So just be made aware of that. Okay. All right. I believe this is the sort of last topic before topic 4. So again, I applaud you all for staying with us this afternoon, and hopefully you're learning a thing or two. This one, my wonderful colleague Danielle talked a lot about structural integrity reserve studies and milestone inspection and those types of reserve items. I'm not going to go in depth, obviously, into that again. This is really my light touch. This is my 10,000-foot view of just the underlying obligations that every condo association has regarding these topics. Obviously, you need to adopt an annual budget each year. That's what annual means, right? It's an estimation, okay? It's a good faith estimate of what your upcoming operating costs will be. So you certainly look at what the annual budget was the prior year, see if there needs to be any good faith changes, and that's what you estimate what your operating cost will be. There's really 2 sides to an annual budget, 2 main sides. One is just the operating expenses, right? These are your day-to-day things. These are hopefully your fixed costs. You know all of these things. It's management fees. It's costs for landscaping. It's, insurance, your accountant, your attorney. Okay. It's all of your operating costs. You know what vendors you all use. You hopefully have your vendor contracts easily accessible. You know what those expenses will be, and you base your annual budget on that, and you'll see what your operating costs are. To adopt the annual budget each year, the notice of the board meeting must be mailed to every owner with a copy of what the proposed budget will be and posted, right? You post the notice, you post it in a conspicuous place in the community. and on the website. I'll talk about the website later, but if you're a condo with 25 or more units, you need a website. So the notice of the board meeting to adopt the budget, the notice is 14 days, got to be mailed and posted with a copy of the proposed annual budget 14 days in advance. Obviously, the person who sends the notice 14 days in advance, they must sign an affidavit that it was mailed properly. I think it's a good point, this last bullet point here. The annual budget is the proposed annual budget. If at the board meeting in that 14-day time frame, or let's say you mail it 30 days in advance, if you get updated numbers from a vendor and there's proper documentation to support that, the budget itself can be changed at the meeting. Okay. Obviously, the board needs to approve at that meeting what the final amount and what the final budget is. But you don't need to re-notice everything if the budget changes in the mail out time frame. Okay, so it's just important to be made aware of that. I want to just briefly, because the law was changed July 1st of 2025, what I call a head scratcher, but they adopted this very convoluted language, and hopefully in future legislative sessions, it'll get clarified. If I had my wish, it would get removed, but it talks about the process if the budget reflects that the assessments are essentially 15% more than the prior year. It talks about the need for a substitute version of the budget. And it's kind of a really sort of a strange statute, because the substitute budget, you're supposed to trim all the fat in their mind, whatever that fat may be. But oftentimes there is no fat on an annual budget. It's a lean, mean operating budget, and you're only including things that you must have. I don't want to get anyone worried about this or too involved. Just keep in mind, if your budget exceeds that 15% threshold from the prior year, the way the law reads now, there is a substitute budget process, and definitely get with your attorney about that, and he or she can walk you through that. Okay. The law was changed about 5 years ago. The annual budget must be adopted 14 days prior to the start of your financial year, right? A lot of communities are on a January 1 to December 31st. You're on a calendar financial year. Not all, right? Some are on a September to October, So just be aware that the budget per law, you are required to adopt it 14 days prior to that. The other side of the annual budget, we talked about operating expenses, are obviously reserves. Okay. And I don't want to, again, spend a tremendous amount of time on this at all, because I know you all are probably reserved out by now. But I think it's important to note, I'm talking about every condo in Florida, not just the condos that are 3 stories or taller, because those are required to have structural integrity reserves, right? SIRS. Every condo in Florida, doesn't matter your height, is required to what I call old school reserves. Some people call them non-SIRS. Whatever phrasing you want to use, you're required to have reserves in your annual budget each year for these 4 items: roof, painting, pavement, and the last one is what attorneys like to call a catch-all, right? It's any other item that has a deferred maintenance expense that exceeds 25 grand. It used to be 10 grand. It was increased to 25 grand. These 4, you want to call them non-SIRS or old school reserves, these are statutory reserves, and you are required in your annual budget to have them, unless, and there's a big unless your owners vote to either partially fund them or to waive them. The law still allows an association, okay, to waive these non-CEUs, these 4 items here. Okay. Again, these are for non-structural reserves. Obviously, I believe Danielle might have touched on it, but the way you compute reserves, I'll give you a very easy answer. Let's say your parking lot needs to be resurfaced every 10 years, and it's going to cost $100,000 to do that parking lot work. To fully fund that parking lot reserve, you would put $10,000. You would fund $10,000 a year, right? So you fund $10,000 a year for 10 years. You have a fully funded $100,000. You have that fully funded pavement reserve. Okay. Like I said, you're going to need to fully fund those non-CEUs unless the owners vote to do either waive it completely or to reduce, which is the same thing as partially fund. Okay. The owner vote required to approve either waiving or partially funding reserves is a majority of all owners. So it's 50% plus 1 of all. It used to be majority of quorum. That was changed. It's majority of all. Okay. So if you have 50 total units, majority is 50% plus 1, right? You need 26 units to vote in favor of, let's say, waiving reserves. Okay, so I just want to make sure we just take a second on that. Certainly, if you're a condo and you're thinking about presenting to the owners the ability to waive or partially fund non-CEUs, definitely get with your legal counsel. He or she could walk you through that process and make sure that your documentation is correct and the voting package that you're sending out is accurate. Okay, just a couple more slides and I'll take questions on topic 3. Those non-CEUs, right? Those 4 items I talked about, those are restricted funds. They can only be used for those reserve purposes unless, right? Unless is a powerful word, and it's right in this slide 128, unless their use for an alternative purpose is approved by the owners. And again, it's 50% plus 1 of all units. It used to just be majority of quorum. That was changed. So to recap quickly, for non-CEUs, owners do have the ability to vote to either waive or partially fund. Owners also have the ability for non-CEUs to vote to take those reserve funds and use them for something else. Again, you need an owner vote, and it's a majority of all. Okay, 50% plus 1. When we talk about pooled reserves, again, that's just the when you're combining your independent reserve items into one pool, and funds can be drawn from that pool for anything that's in that pool. So if you have a non-CEUs pool, obviously the funds in that non-CEUs you can use for those non-CEUs reasons, but you wouldn't be able to use funds in your non-CEUs pool for something unrelated to the non-CEUs items without getting that owner vote. Okay. When you take an owner vote to, let's say, waive non-CEUs reserves or to use non-CEUs reserves for an alternative use, the statute, it's in 718, this bold and all caps language right at the bottom of slide 129, make sure your voting materials, you're going to use a limited proxy almost always. Make sure it has that bold and all caps language there. Okay. Last 2 slides before topic 4. Okay. And again, thank you for being so patient. The other financial item is just the annual financial report. Hopefully you all know, obviously you need to get a financial report prepared each year. Owners get a copy of that report for free, or they get, they get notice that a free copy is available to them. Okay. So owners get a copy of that. and you have to send them the final financial report between 21 and 180 days of when your financial report is completed. Okay. So whenever your financial professional completes it and sends it to you, it's got to then be provided within between 21 days and 180 days after that. Okay. So make sure you're aware of the financial reporting requirement. Just very quickly, the level of financial reporting is based on what your annual revenues are. The higher annual revenues, obviously the higher level of financial reporting. Okay. So if you have between 150 and 300 grand of annual revenues, you must prepare compiled financial statements. If you're between 300 and 500,000, you must prepare reviewed. And if you're 500 or above, it's an audit. And if you're less than 150 grand, it's just a simple report of cash receipts and expenditures. Now, let's say you have 800 grand of annual revenues, you must do an audit. The board can only lower that level of financial reporting with an owner vote. Okay. The board on its own can never lower the annual financial reporting requirement. Okay. You need to get an owner vote, and it's a majority of all owners. On the flip side of that, let's say your association has $400,000 of annual revenues. Per statute, you only need to do reviewed financial statements. However, the board on its own, they can say, look, we never had an audit done. We know we're not required by law, but we do think it's been a long time. It wouldn't make financial sense in our judgment. We think this is the right call. We want to get an audit. The board does have the authority on its own to increase the level of financial reporting. All right. With that, we made it through topic 3. I appreciate that. I'm going to take a look at some of the questions that have been sent in since I've started. And again, I really appreciate you all taking the time out of this. All right. Okay. Some of these were from prior in the day, and they've either been answered or. Okay. I got a question about the fining committee and who can serve. In my opinion, it needs to be unit owners. Okay. So non-owners wouldn't be able to serve. We got another question about the board meaning to levy the fine or to levy taking away someone's use rights. That is an open meeting. That is not a closed board meeting. That is an open one. We got a very specific question on how the condo docs can be amended, dealing with bank foreclosures and priority of a claim of lien. That is a very good question. That's a very document specific thing. And usually I'm good, and I'm sure Danielle and Jeff did this, but let me give my my attorney spiel quickly here. Obviously, what we're going over today is general information, right? This isn't direct legal advice, obviously. So it wouldn't be appropriate for you as a board member to go back to your other board and say, I met with an attorney, we got advice, this is how we can handle this thing. Like anything in life, the facts really matter. And a lot of, condo law things are very fact specific. So make sure if you have a specific legal question, get with your current attorney. All right. Okay, we got a last question that I believe is appropriate for now. Then I'm going to go on to topic 4. Not exactly on topic, but a question about special assessments where they had this board had to levy a special assessment for a required repair project. And the question is, can we use those special assessment monies for something else? And the answer is, it really depends. The purpose of the special assessment by law must be clearly set forth in the notice of the board meeting that is sent out. It has to say the board will be considering a special assessment in the total amount of this for the following reasons. And you list those reasons. If you have special assessment money and those reasons, all those projects are complete, and you have some surplus special assessment funds, yes, you can use those surplus funds for another bona fide association project, with a key caveat. The original purpose, those projects must have been complete. So let's say you're doing concrete restoration. You levy a special assessment just for that. You have excess or surplus funds from that concrete restoration project. That concrete restoration project must be over in order for the board to use those excess funds for another bona fide association reason. If the project's not over, okay, the board would have to hold a whole nother 14-day notice board meeting to clarify what the purpose of the special assessment is. Okay. So somewhat of a long answer, but I thought that was a good question that hopefully some of you could learn something from. All right. Next topic. This is really sort of the bread and, the bread and butter of condo operations. And I try to hopefully make it as simple as possible. Meetings of the members. Members is a fancy word for what? The unit owners. So you want to think in your mind, there's really only two types of every time there's a meeting of the association, it's either an owner's meeting or a board meeting. Those are really the two main types. And if it's an owner's meeting, obviously the owners are voting. If it's a board meeting, only the board is voting. I know that sounds common sense. You're probably thinking, why is Andrew explaining that? I've seen many notices of a meeting where they blend the two. One agenda item, the board's voting, the next one, the owner's voting, and that's technically not correct. They should be two separate meetings. If the owners are voting, it's a separate owners meeting where you need a quorum of the owners to be there for that meeting. If the board's voting, you have a separate board meeting where you have a quorum of the board there, okay? The most common meeting of the members, again, members and owners means the same thing. The most common is the annual, right? That's where the election happens, but there could be other types of special members meetings as well, where the owners are voting, to maybe waive funding non-SERS reserves, or like I said previously, to approve an amendment to your bylaws or to approve a material alteration, okay? What I want to share with you is the statute was recently amended, obviously before 2020. I don't know how many of you really knew about Zoom or any of this remote technology, right? So obviously when COVID happened, almost all communities transitioned to having meetings over Zoom or some sort of remote way. And a lot of boards liked it, and they kept Zoom going forward, okay? The law was changed, and I'm going to get into it a bit, but really, you shouldn't be having Zoom-only meetings now. Definitely for a board meeting, you should not be having Zoom only, okay? And I'll talk about that soon. If you want to offer Zoom, it should be a hybrid. You have a physical location as well as offering Zoom. But again, this is pointed out in the third bullet point right here, there must be a physical location where owners can attend, okay? So it's got to be a hybrid. We get asked a lot, do we have to offer Zoom? The answer is no, you don't have to offer Zoom. You can go back to the old school way, where meetings were held in a physical location. Okay. This is a change in the law, and hopefully this will get changed in the future, because this is a head scratcher. But I want everyone, if you're still paying rapt attention, and I know you are, just read this slide for a second while I take a sip of my almost warm Starbucks. Okay. What this slide says is what? At the annual meeting, a quorum of the board must be physically present where the unit owners are. And I submit to you why. Why does that matter at all? I mean, I can list many reasons why this is a head scratcher. First thing is, what if the old board, what if those directors aren't even running for the board again and there's an election that night? They're only on the board for another hour. Why should they be dragged to physically be there? It doesn't make sense. Also, an annual meeting is an annual meeting of the owners. So you need a quorum of the owners. Quorum of the board does not matter. I'm not naive to think, I mean, the rationale is they want some board members, the current ones, to physically be there. But I just think this is a head scratcher. Doesn't make sense to me. With that said, that's what the law says. Our firm is involved in the various legislative action committees, and we do our very hardest to help draft sort of common sense changes. We obviously don't always get what we want. Most of the time we don't get what we want, and this is certainly, I think, a head scratcher. But just be aware of that. If you're a condo, you're having your annual meeting, you're offering Zoom as an option, you don't have to, that you need at least a majority of the board's got to physically be present there. All right. We're still talking about meetings of the owners. Okay. Check your bylaws and what the notice requirement is. Almost always it's a 14-day notice requirement. Just be aware of that. Again, the annual meetings is a whole different process. And I believe Danielle talked about that, so I'm not going to go into the whole election process, but special meetings of the owners, you got to make sure you're sending notice at least 14 days out in advance, and there needs to be an agenda, obviously. You need to post the notice also. So if you mail it 14 days prior, you got to post the notice in the community 14 days in advance. And if you have a website, 25 or more units, you need to post it on the website 14 days in advance as well. I think this is an important slide, and I want to just take a second on. We get asked a lot, can we email the notice? Let's say, hey, Andrew, we're voting on a material alteration. We're knocking down our old gym. We're putting up a brand new clubhouse. Our documents require an owner vote. It's a material alteration. We want to do this vote at a special meeting of the owners. Rather than sending in the mail the notice of the meeting and the notice package, can we just email it to the owners? It'll save on cost. And my answer is, it depends. It depends on something fairly straightforward. And that is, you can email notice as the exclusive method to send notice only to those owners who have consented in writing to receive official association notice via email. Okay. So if you want to save on stamps, you want to email notice, get with your current counsel. They can draft a very simple email consent form. You send it out to the community. I'm John Smith. I'm an owner. I get that form. I say, John Smith, here's my email. I date it. I specifically say I agree to receive official notices to this email address. If you have that signed consent on file, the answer is yes. You can use email as the only method to send notice. If you don't have that signed consent, you have to send the notice package via regular mail. You can send it email as well in addition to, but you can't avoid sending it regular US mail. Also, very important, if you have a signed consent from an owner on file to use his or her email as official notice, that email address per statute becomes part of the official records that other owners get to inspect and copy if they so choose. So once you have the signed consent from that owner to use their email address for official notices, that email is public, quote unquote, information that other owners can ask to see. All right. Website posting. And I'm going to make a note. And Jeff, if you're out there still, make a note that this 150 should read 25 because this was recently changed. So I apologize about that. But if you haven't, this was changed as of January 1, 2026. It used to be 150. It is now 25 or more units. You need to have a website. Okay. So just be aware of that. And I'll get into a bit more about that. But the main takeaway is that I'll just go back to this. The main takeaway is per statute, there's a list of items that must be on the association website. I have lots of boards. I've simply copied and pasted, no charge. Here's what the statute says. Go down this list. Make sure these items are being transferred to your association website. Again, it's 25 or more units.
The slides that people will download after the evaluation, it'll be fixed. I'm doing that now.
25.
So
awesome. Thank you. No, we strive to be 100% perfect 100% of the time, but like all humans, we fall short from time to time. All right, we're still talking about owner meetings. Obviously, to have an owner meeting, you need quorum. Quorum is just a fancy word that means the minimum number of owners that are present at the meeting for the meeting to happen. Almost always, the documents will say a quorum is a majority of all, right? 50% plus one, okay? There could be a lower number. I've seen it. I've seen quorum be 1/3, okay? If you're not sure, don't just say it's a majority of all owners. I can't tell you how many meeting packages I've reviewed that have either been prepared by management or prepared by the board that has the wrong quorum number there. It's a very simple thing to ask your counsel to confirm what your quorum requirement is, but oftentimes it is a majority of all owners. Quorum can be established multiple ways. It can be by physically attending. If you submit a proxy, right? Proxy could count towards quorum. Also, if you've instituted electronic voting through a third-party vendor, right, where an owner opts in to vote electronically, the submission of that electronic vote counts as quorum as well. So just make sure you're aware of what your quorum requirement is for owners' meetings. And just keep in mind, if you don't establish quorum, that meeting can't happen. The business of the meeting can't happen. Having said that, proxies are valid for 90 days from the meeting date. So you don't necessarily need to adjourn that owner's meeting, right? You could recess and reconvene it to a later date. Let's say you're having a special owners meeting again to vote on a material alteration project. Let's say you don't have quorum, or let's say you need 75% owner vote and you're a few votes short. You can recess and reconvene that meeting to a later date to have more time to collect proxies. Again, proxies are valid for 90 days. So make sure you don't recess and reconvene past that 90-day period. You can recess and reconvene multiple times as long as it's within that 90-day period. And certainly you're going to want to get with your current counsel to kind of walk you through just to make sure the minutes of the meeting accurately reflect that recess and reconvene process. All right. Obviously, that's a bad habit. Hopefully, you all know that owners have the ability to participate in owners' meetings, right? In addition to attend, they can speak on what the agenda items are. The association has the right, per statute, you can adopt the rules regarding how those owner statements are made, but they do have that right to speak. Also, they have the right to record. An owner can record a meeting. So if it's an owner's meeting, they have that right. They have the right for board meetings as well, and I'll get into that. So you can't stop an owner from recording a meeting. They do not need your approval, okay? The statute allows them to record. Obviously, they can't be running around the room shoving their iPhone in your face, right? You can adopt rules that say, stay in one place. You need to give us advance notice that you want to record. There's certain rules that can be adopted, but you can't completely prohibit them from that.
Hey, Andy, just a quick thing. It's about to storm where I'm at. So if you lose me,
okay,
I'll be back as soon as my generator kicks on. I think it'll be okay, but just
no problem.
All right.
Stay safe, Jeff. Stay safe, please. Also, voting for owners meetings, you're gonna, if there's an owner vote, and we list some examples here, you're gonna use a limited proxy. Okay, that's when I'm an owner. I don't want to physically show up to the meeting. I cast the vote how I want to vote on that limited proxy. I sign it. Then the proxy holder, whoever I fill in, or if it's blank, oftentimes it defaults to a member of the board. That proxy holder is at that meeting, but they don't vote how they want to vote. With a limited proxy, I vote how I want to vote as the owner. I just don't feel like physically going to that meeting. And there's definitely something you get with your counsel to make sure your limited proxy has all the required information there, especially if you're voting one of the first items at the bottom of this slide, 146. If you're voting on anything regarding reserves, you need to include that bold and all caps language I talked about earlier. Okay. This just talks about proxies being valid for a 90-day time frame. I spoke about that previously, and hopefully you all know for the election to the board, proxy voting is not allowed, right? Election to the board, you do it via the inner and outer envelope process, or if you have electronic voting. All right, a couple more topics on meetings. We have meetings, we have insurance, then we have conflicts of interest, and then we'll call it a Friday afternoon. So I appreciate it. We are past the halfway point. So thank you again. Meetings of the board generally, but this is probably the slide that I think I've referred to this slide in every presentation I've done my entire career as a condo attorney. In my 20th year, which is pretty wild to say out loud, and I always talk about the fiduciary duty of the board, and I just think it's such an important concept. It transcends condo law, right? This really is for any board of any corporation, whether you're a for-profit or a not-for-profit, like a condo association. But we're in the condo world now, and you as a board member, you have a fiduciary duty. What does that mean? Fiduciary is just a fancy word, okay? It means you're in a position of trust. So every decision you make, the primary focus should be, is this in the best interest of the entire community? Because you were typically elected, maybe you were appointed, but you're in this role. Okay, you're on a board, you have a fiduciary duty. This fiduciary duty, and it's an obligation. Okay, it's in the statute, it is referenced in the statute. There's even language in chapter 617, which is the Not for Profit Corporation Act. So, what does that mean? When you are thinking about, is this in the best interest of the entire community? Courts historically have looked at whether the board used reasonable business judgment. What would an ordinarily prudent member of the board, what would he or she have done if presented with the same facts? And if you took action in the same way that an ordinarily prudent person on the board would have acted, you would have exercised reasonable business judgment. Now, we can argue about what's reasonable and what's not. That's why there's attorneys out there. But generally, courts are very reluctant to substitute its own business judgment for that of a board. So, using reasonable business judgment, what should that include? It should include the due diligence process. You rely on your licensed professionals. If it's an insurance question, talk to your licensed insurance folks. If it's a accounting question, get with your licensed financial professional. Management, your licensed manager. A question about the law, obviously, get with your current attorney. So you rely on these licensed professionals to provide you their views on the topic. You gather all of that, you evaluate it, and you say, this is what I think as a board member, what I think is in the best interest of the entire community. If the decision turns out not to be the correct one, that does not mean you breached your fiduciary duty. Okay. So I think it's just very important to kind of take a second and just really reflect on that. Okay. That's your most important obligation that you all have. All right. Again, part of your duty as a board member is binding decisions of the association are almost always made by the board. The exceptions are if the documents require an owner vote or the statute requires an owner vote. Obviously, you have to get an owner vote. But absent that, decisions of the association are made by the board. No one has on the board unilateral authority to bind the association. Okay. The only exception is if a majority of the board has previously approved assigning that unilateral authority to one member of the board. Absent that, decisions should be made by a majority of the board. This slide hopefully is somewhat common sense, but sometimes the state, when they adopt laws, they react to anecdotal horror stories out there. And there's certainly from time to time, you can search online, you can search, condo boards gone bad, and you'll find some anecdotal stories about a board member stealing money or doing some sort of crime. There was a huge story a couple of years ago in Miami-Dade County, the hammocks community. I'm sure lots of you have heard about it. If not, it really reads like a true crime series. So yes, there are bad actors out there, just like in any walk of life. But my experience is I applaud my board member clients who volunteer, right? The pay is not very good, right? $0. You volunteer your time. But this slide is just important to know. Obviously, kickbacks are illegal. A kickback, you've heard that phrase. It's where perhaps a third party that the board's considering hiring gives money to the board to influence their vote, or they inflate the contract price and they give you some funds. It's a crime, right? You can't accept something of value where consideration hasn't been exchanged. Okay. So if a vendor's offering you money to vote for them, obviously, hopefully, that raises extreme red flags to you all. Also, I think it's an important point because some of you may not know this. While a credit card is okay, a board can have an association credit card, a the debit card is not allowed. Okay. So that's in the last bullet point on slide 151. Just be made aware of that. Okay. I'm not going to read this slide line by line, but hopefully you all never have to deal with this. But if a member of the board or an officer is charged, doesn't mean convicted. If he or she is charged with certain crimes, and the list is right here, they're automatically removed from serving even before that criminal case has been resolved. Okay. So just be aware of that. The list of crimes are there. It's, theft crimes, destroying official records, obstructing justice. So if they're officially charged, the state charges them with that crime, they're automatically off. Okay. Now, if the charges get resolved and without a finding of that director being, they're not guilty, that officer does get automatically reinstated. But I think it's just important to talk about that. This, I think, is a really informative slide. So I just want to take a minute on this. How to get off of the board, right? We get asked a lot, whether it's from a group of concerned owners or maybe there's board members are concerned about a board member that's kind of gone rogue, or they're just curious about how to get someone off of the board. The first way is obvious. It's that person can just resign. That resignation should be in writing. Okay. We don't want just a verbal one because people could claim that's not what I said. That's not what I meant. I was joking. There could be a million things. If someone wants to resign, just have them resign in writing. The second way is the actual recall process. And just a quick note, this does require an owner vote. To recall someone from serving on the board, you do need a owner vote. It is a majority of all owners. So 50% plus one. That's the recall process. If you're a concerned owner and you have other concerned owners and you're thinking about doing a recall process, I suggest getting with a Florida licensed attorney who knows what they're doing to make sure you get the recall agreement completed properly before you spend lots of time going out and getting owners to sign it. You want to make sure it's done right. At the same time, if you're on a board and a majority of the board wants to recall one member of the board, get with your association counsel so he or she can assist you with that recall process. You want to make sure it's done right. The third way is if a member of the board is more than 90 days past due, they're automatically off. They're automatically off. If you have a current board member that's more than 90 days past due, they're automatically off. Obviously, criminal charges, that's the slide I just talked about. Also, if the state of Florida via the DBPR could order a director off of the board. The final one, it really isn't that serious, but you should be made aware of it. You need to be you have to satisfy the board education requirement. If you don't timely do it, you're not permanently removed. You're just temporarily off the board until you satisfy it. And any action that you took is still valid. So the last one, the sixth one, there's not really a lot of teeth there. It's just to encourage people to get certified. All right. Talking about board meetings, the law was changed not too long ago. Hopefully you all know, but you have to meet once a quarter, right? That's at least 4 times a year. And at least 4 times a year, the agenda must include the ability of owners to ask questions of the board. So it doesn't necessarily need to be just on an agenda item. At least 4 times a year at a board meeting, owners get to ask questions of the board. Okay. Again, board members can definitely email each other. You just cannot vote via email, right? Voting on matters must be done at duly noticed and open board meetings. I'll just talk quickly. Ratification, or to ratify something, that's just a fancy word. It means you're formally approving something after the fact. Okay. Ratification should not be used as like a, regular course of operations, but sometimes there's something that must get done and the board is unable to meet. If that happens, make sure at the next board meeting that gets ratified, right? Let's say a pipe burst, there's flood damage everywhere. The board needs to get a vendor in there immediately. The board has to take action to protect the condominium property. Just make sure the hiring of that emergency water remediation company gets ratified at the next board meeting. Most board meetings, notice just needs to be posted 48 hours prior, right? The notice has to have an agenda. There's a couple board meetings where you do need to mail notice and post notice 14 days prior, right? If you're adopting a special assessment or a rule regarding the use of the individual units themselves, that board meeting must be mailed and posted 14 days prior. Again, hosting board meetings via Zoom. Zoom only meetings are not allowed. Okay. The law was changed. You need to have a physical location as well. So do you have to offer Zoom? No. If you do, you need a physical location. Importantly, if you offer Zoom, you have to record the meeting. And that Zoom, I'm just saying Zoom, there's other software out there, but if you do offer Zoom, you need to record the meeting, and that Zoom recording is part of the official records. Okay. Very important. All right. This is talking about posting board meetings. Again, Jeff, if you're out there, hopefully you're staying safe.
Yeah. We've had another page here. Okay.
Another page. Yeah. So hat and hand, that should read 25 units instead of 150. But again, we're talking about the association website requirement. If you have a board meeting notice, you're adopting a rule regarding the individual units, you got to mail and post it 14 days prior, and you got to post it on the website 14 days prior. Okay. The board notice, like I said, has to have an agenda item. Okay. If the item's not on the agenda, the board cannot formally approve something at that meeting. The only exception is if there's an emergency basis, the board can add an item. It would be by vote majority +1 of the board members can take up an emergency action that's not on the agenda. Okay. Then such emergency action's got to be ratified at the next board meeting. Sometimes owners really want the board to address something at a board meeting. As it's a board meeting, the board sets the agenda. However, the statute does provide for a process for the owners to force the board to put something on the agenda. You do need 20% of the owners to say, we are submitting this written request to add this item to the agenda. Then the board has 2 months to do so. Okay. All right. Again, I don't want to read every slide line by line. I want to talk about, those issues that we see a lot. Okay. Again, just like owners meetings, at board meetings, owners have the ability to attend and to speak. They can record them as well. The only board meetings that are not open to owners are numbers 1 and 2 on this slide. Okay. That's when the meetings with the association's attorney and the meetings regarding, proposed or pending litigation, or basically rendering legal advice, that meeting can be closed. Okay. Oftentimes there might be a pending lawsuit and a settlement offer has been made, and the board must formally vote to approve that offer. That board meeting with the association's attorneys present can be closed. Okay. The second type of board meeting that can be closed is if the meeting is to discuss personnel matters, right? What that really means is, let's say the association has an employee and the board has decided to go separate ways, where you're terminating that employee. That board decision needs to be done at a board meeting, but that board meeting can be closed. You still should post notice 48 hours prior. It should just read closed board meeting discussing personnel matters. Or if the attorney's present, you would say closed board meeting with the association's attorney regarding, pending litigation matters. Okay. So just be made aware of that. Again, this is just talking about the owner's ability to speak at board meetings that have that right. Again, the board also has the right per statute to adopt reasonable rules regarding when and how the statements are made. Lots of boards say, hey, you have a total of 2 minutes or three minutes. We'll take questions at the end of each agenda item, or statements at the end of each agenda item, or statements at the end of the meeting, whatever the board thinks is the best fit for them. But you should have, if the board wants to, have those types of rules, the board should formally adopt those rules at a board meeting with the minutes reflecting that action. All right. Again, just like owners meetings where you need a quorum of the owners to be there for the owners meeting to happen, you obviously need a quorum of the board to be there, right? And quorum is a majority of the board. So if you have a 5-person board, you need 3 of them there. If you have a 7-person board, you need 4 of them there. 9-person board, you need 5 of them there. A board member for board meetings can establish their presence for quorum via speakerphone. They can call in. That's totally fine. Okay. You don't have to allow owners to call in, but you can absolutely have a board member call in to establish that board member's attendance for quorum. Just make sure you use speakerphone so the owners that are there can hear that board member speak. Okay. So just make sure you're aware of that. Unless the documents say something else, right? It's a majority of the board. They are the ones that bind the corporation, right? And I talked about earlier, no single board member has the authority to bind the association unless that single board member was previously assigned that right by a majority board vote. Also, directors at board meetings, they don't vote. It's not a secret vote. Okay. Board members must vote out loud so owners can hear how each board member voted. The only exception is when the board is electing the officers, right? President, vice president, treasurer. The board, if they want, can vote. They don't have to vote out loud for that, but everything else you need to vote out loud. And really, a board member should not abstain from voting unless they have a conflict. All right. If there's a conflict of interest, then certainly that board member should abstain. But without that, board members should be voting on things, right? You're in that role. You should be expressing your views, whether you're in favor of something or you're not in favor of something. And obviously, the minutes of the board meeting, that's the corporate record of the association. That is the document that says this is what happened. Okay. Minutes do not need to be a transcript. Okay. You don't need to write down every single breath that any person, said, but it should absolutely, not should, it needs to show every motion that's made. Just identify there was a second to that motion, and then definitely identify how the vote was done. If it was unanimous, you can just say, if you have a 5-person board, you can just say the motion was approved unanimously, 5-0. Okay. If it's not unanimous, you should say it was approved 4-1 or whatever the case is. Okay. But just make sure that the minutes accurately reflect that. Another thing, this is sort of a misconception out there. Committee meetings are subject to the notice requirements like board meetings are. The only exception is if your bylaws specifically exempt committee meetings from the notice requirements, which is pretty rare unless your documents were recently amended. So if you have an official committee of your association, unless your bylaws exempt them, they're subject to the notice requirements. Okay. So this is an important slide. There's 2 types of committees that cannot be exempted in your bylaws. That's a committee that gives guidance on what the annual budget will be. That's always open to the owners, and notice is always posted. Or if that committee's entrusted with final action, okay, that meeting always has to be open, and your bylaws cannot exempt those 2. All right. Just a couple more main topics, then I'll open it up to questions, and then we'll get on with our wonderful rest of the Friday here. Let me just take a pause. Let me take a couple questions on that.
And while Andy's looking, just to let everybody know, in the chat area, we did place the link for the required post-webinar form in there, so you can get a head start on that right now if you choose to. But please remember to remain on until Andrew gets through with the final slides. But again, you can get a head start with the online form. The link is in the chat. Thank you. Back to you.
You got it. And if I'm not answering your question, please don't take it in any personal way. Some of them are very specific. I'm getting questions about specific architectural applications and all of this stuff. That's sort of outside the scope of what we're talking about today. I got a question about, owners attending board meetings. Absolutely. Owners are entitled, and they should attend board meetings to know what's happening. We got asked about a credit card. Like I said, an association can have a credit card. If an individual director uses his or her own personal credit card for an association reason and expects to be reimbursed, you need to make sure you have clearly defined reimbursement protocols established. Okay. You don't want just some one person on the board doing a bunch of things that he or she thinks is going to be reimbursed, and then you have a big fight on your hands. Okay. Make sure you have clear financial and reimbursement protocols established. I have someone alleging possible bribes from a contractor, that would be a crime. So you should absolutely, if there's proof, not just rumors, right? But if there's proof, you should contact local law enforcement for that. Got asked a question about committee meetings, which I just spoke about, that they are subject to the same notice requirements as board meetings. You want to think of them as the same exact thing. The only exception is if your bylaws specifically exempt committee meetings from the notice requirements. In my experience, that's somewhat rare unless you've had your documents amended. Got a good question about for closed meetings. Should there be minutes of that meeting? In my opinion, yes, but the minutes are what? They're private. Those are closed. They're not, open for inspection by owners. But to me, you should have minutes of closed board meeting. Again, quorum for board meeting is a majority of the board. We got a question about our board is 6 total seats. I find that somewhat unusual. Usually there's an odd number of total seats. Sometimes you can't fill all of them. Let's say you have 7 total seats. Sometimes you can only find 6 human bodies, right, to fill that. But your board is still 7. Just because you only have 6 bodies to fill those 7 seats, your board is still 7 total seats. So quorum of 7 is 4. If you truly have 6 total seats, again, that's somewhat odd, but quorum for a 6 total seat board would be 4 because it's 50% plus 1, right? Okay. All right. I got asked a question, should the board follow what's in our governing docs? And my answer is yes, they should. All righty. Again, just a couple more topics, and I really appreciate all of the wonderful questions. Talk about insurance a bit. We're going to talk about property insurance, right? Whether you want to call it property or, casualty insurance. But a board's required to use its best efforts to obtain and maintain adequate insurance. Okay. And this is in the Florida statutes. Okay. And you're supposed to get what your replacement cost would be. It's based on your appraisal, and you must have that done once every 3 years. Okay. Give me 1 second here. All right. So talking about, let me go back to this. Let me talk about property insurance first. Okay. This is in the statute, and it starts with a big concept, which is the association is responsible to insure everything. Okay. Every part of the condominium. Then the statute says, except for, and it lists exceptions. Those exceptions are what the individual owners are responsible for. And in this slide here, 169, it talks about specifically what the owner's obligation is. And it's things that make sense. It's interior unit items. It's personal property. It's the coverings of the floor, the ceilings, the walls. It's electrical fixtures. It's appliances, water heaters, cabinets, window treatments, everything that you read here, okay? It is the owner's insurance obligation, and everything else is the association's insurance. Now, why is this important about who insures what? It's important because let's knock on wood somewhere, but this comes into play when there's a casualty event. And that essentially means a sudden, unforeseen thing, like an act of God, a hurricane, a fire, some unforeseen event. And there's damage to the condominium property. The legal analysis is whoever is responsible to insure the item, they're responsible for the cost to address the damage to that item following a casualty event. So let's say, for instance, again, God forbid, there's a hurricane or a fire, okay, and an owner's cabinets are damaged. Per statute, since the owner's responsible to insure the cabinets, they're responsible for the repair cost of that item. On the flip side, the roof of the condominium is the association's insurance obligation. If there's a fire and the roof is damaged, since the association insures it, they're the party responsible to pay for it. It seems like common sense when you think about it, but that's just a good rule of thumb. Following a casualty event, whoever insures it is the party responsible to pay for those repair costs. The exception, and there's always exceptions, right, is if the source of the casualty event was the improper action of an owner. And I'll give you a fact pattern that our firm dealt with. A unit owner, for whatever reason, thought it would be a good idea to use the sprinkler in their unit for their clothes hangers. I'm not joking. Obviously, the weight of the hangers broke the sprinkler, immense water damage. That action of using the sprinkler for your, clothes hangers, that is improper conduct. That's unreasonable. Okay. That should not have been done. In that case, the association can seek reimbursement from the owner since the source of the casualty event, because it's still a casualty event. That's a sudden, unforeseen thing. So I just wanted to point out that exception there. All right. I believe we're in the home stretch, and then I'll definitely take questions. All right. So I think just my outline was out of order for a second. I can deal with that later. All right. Conflicts of interest. Probably one of the more, maybe misunderstood concepts. And I want to kind of give the ending of the story first, which is what we're talking about here is when a board is considering hiring a company where a director or a family member of a director has a financial interest in that company. An easy example, board member Sue Jones. She owns a landscape company. Can the association, via that board vote, hire Sue Jones's landscaping company? Most people just a reflex will say absolutely not. And that's not exactly correct. Okay. The law does allow for that contract to happen. I'm not suggesting it's a great idea, but I'm just giving you what the law says. Okay. The law says to use that fact pattern, the board can hire the board member's landscape company, but there's several steps that must be followed. And these steps are in two parts of the statutes. One part is chapter 718. Okay. It's section 718.3027. And another part is chapter 617, which is the Not-for-Profit Corporation Act, which includes condominium associations. And that's section 617.0832. And what these steps are really disclosures that Sue Jones must make. Okay. So again, I'm not suggesting this is a good idea. And if the board wants a policy, we're not going to go near Sue Jones's landscape company with a 10-foot pole. That policy's fine. But I just want to give you the full answer here, which is the board could hire Sue Jones's landscape company if at the board meeting, Sue Jones discloses that, hey, I'm the owner of this landscape company. The minutes of the board meeting reflect that Sue Jones disclosed that. The notice and agenda of the board meeting has to have the landscape contract there so owners can see it. And then Sue Jones can't vote on it, right? She must abstain from voting. She actually has to leave the meeting while that agenda item regarding hiring her landscape company is being chatted about and voted on. Sue Jones has to not even be there at all. And you need 2/3 of the board. Again, Sue Jones is abstaining. You need 2/3 of the board to approve it. And the terms need to be fair and reasonable. Okay. And again, this slide here kind of walks you through these things I just spoke about. If all of those disclosures are done, the minutes of the board meeting are correct, the contract was on the notice, 2/3 of the board approved it, it's fair, it's reasonable, the law does allow the association to sign that contract. The one caveat is at the next meeting of the owners, okay, the owners can vote to cancel that contract, okay? Again, I'm not saying it's a good idea, but I just want to make sure that you have the correct information. I can envision a fact pattern. Let's say a board member or a relative of a board member, they own a very specialized engineering firm. They're the best seawall engineers in the, Broward County or whatever county you're in. They are the best at what they do. And you, as an association, have a very complex seawall project, and you want to make sure you have the best engineer working on that. I do think it's not unreasonable for the board to consider hiring this engineering firm, right? Again, the conflict of interest disclosure requirements must be carefully met. I suggest getting your association counsel involved to make sure all the I's are dotted and the T's are crossed. But it's just important to be aware of that, okay? Again, these are some of the steps about that. And if the board votes against hiring Sue Jones's landscape company, then obviously Sue Jones is supposed to tell the board that, they're not going to go forward with that, which to me makes sort of common sense. But all right, let me wrap up a couple things. I just want to point out there's some new language to the statute regarding management company conflicts of interest as well. And if you're a manager or you work at a management company, you should be aware of your conflict of interest requirements as well. A lot of management contracts, if you're on a board, you'll see a paragraph where the management company shares with the board, hey, we have a financial interest in these other, companies, right? And they're sharing with you, they have a financial interest in them. That does not mean you as a board have to hire these other companies, but it's something for you all to be made aware of, okay? All right. With that being said, we do have some time. I want to make sure I get to whatever questions you all have. And again, I really appreciate you all here. Let's get to some questions. Question about a small condo. There's only 9 units. Should every owner be on the board? There's no right or wrong answer there. We actually have some clients that are that small, and sometimes every owner is on that board. That's a document specific thing. So you need to look at, usually it's in your articles of incorporation or your bylaws that talk about what size of the board is. We're getting some questions about water leaks and water intrusions. These are very fact specific things, drains and water lines that Are they the horizontal plumbing pipe? Or are they going up and down? I mean, there could be a million. There could be a lots of different facts. What I will share with you is there's a misconception out there that some people think that if the plumbing pipe only services one unit, no matter what, that owner's always responsible for that pipe, no matter where that pipe is. And I'm here to tell you that's not always the case. And I'm talking about general maintenance. I'm not talking about an insurable casualty event. I'm just talking about wear and tear, right? Who's responsible for that pipe? That's a document specific thing. And it's not always the case. Sometimes a pipe is located outside of the boundaries of an individual unit, and the boundaries of the unit are defined in the governing docs. And sometimes the docs will say if a pipe is located outside of the boundaries of the unit, it's the association's responsibility, even though that pipe may only service that unit. So we've done lots of amendments for our clients where we clear that up, where we draft language to say if the pipe only services one unit, it's that unit owner's responsibility regardless of where that pipe is. And that regardless phrase, it can be a very important phrase. So definitely get with your association counsel if you have questions about who's responsible for the general wear and tear repairs of those plumbing lines. Okay. Again, I'm getting asked questions of who fixes what. That's a document specific thing. All right. I got asked, this is a very good question about, can we post a delinquent owner's name in the monthly budget report? I'm not a fan of being proactive and posting names of owners that are past due. And the reason why is quite simple. Let's say you post that report at 3:45 today, and an owner who's on that list walks into the office and pays his account in full at 4 o'clock. At 4:15, that list is still up there. You now have posted a list that is inaccurate, and you have falsely stated that this owner is delinquent when he or she, in fact, is now paid in full. So to avoid all of that, our general advice is to not be proactive and post delinquency reports.
I
Again,
say, even if it's done electronically, there's always typically a time delay. So you could have the same situation for something that you would think would be instant, but there's a time delay.
exactly right, Jeff. And also the account ledgers, those are official records. So if an owner says, I want to inspect the account ledgers of the owners, that's fine. You have to provide them access to that. But providing access to an account ledger pursuant to a record inspection request is it is not the same thing as the board being proactive and posting a list of owners who you think are not paid in full. With that being said, I know we're a couple minutes early, but before Jeff does his final words, again, I want to thank you all very, very much. I know it's a long course with a lot of information out there. Hopefully you enjoyed it and have a great rest of the week, and look forward to hopefully seeing some of you all soon. Thank you all. Jeff, thank you.
Great seeing you. Take care of yourself.
Thank you.